his ex-wife. When I say a monster, she's a monster. His ex-wife is bonkers. So I'm being portrayed as this abuser. This is what happened. So I'm the one that's not portrayed like I don't have a job.
Because George is good.
See, that is just not fair. Not fair.
Welcome back. Today we dive into part 2 of our exploration of Sarah Catherine Boone Paulsen's
Excuse me. You're eating my peach.
disaster of a pretrial statement. In part 1, we covered a big chunk of it, but like I mentioned in that video, there was an exporting issue, so the one large video had to be split up into 2, and this is part 2. I think tomorrow or a few days from now, I'm also going to post me reading this document straight out with no commentary so that the people who just want to hear the document can just hear the document. But if you're here for the rants, trust me, I got them. And if you're new here, welcome to the world of long-form rant content where there is no structure or goal. It's just me reacting to whatever I'm reacting to, and the video is finished whenever it is finished. I assert no authority on this channel. These are all my opinions. You take what you take, you leave what you leave. But if you leave a like on the way out. That's just good home training. And shout out again to Human Tooth for sending me this document. It definitely is one of a kind. Just like most things with Miss Paulsen.
Excuse me.
There was a clown!
Eating my peach.
Where the fuck is he? Where is he? Where is my son? He's escaping! My son is escaping! Help me!
So, with all that out of the way, let's dive right in.
Respondent's motion for contempt. Florida law mandates compliance with court orders unless a modification has been officially granted. Petitioner has continuously failed to pay alimony as ordered by the court in the marital settlement agreement and final judgment without any such granted modifications. His willful violation of deliberately refusing to comply and without any justification or permission is contempt. Petitioner filed a motion to continue on respondent's motion for contempt, arguing that pending his modification petition constituted a change in circumstances under Rosenblum v. Rosenblum, 2015. This case states that a party cannot be held in contempt if they lack the ability to pay, which petitioner does, but actively chooses not to as ordered while being encouraged by his counsel to continue such contempt. Assuming without any family support, resources, money, an attorney, or inclusion, respondent would surrender to her circumstances and the petitioner. However, Rosenblum requires a showing of financial incapacity, not merely a change in circumstances of the receiving party, such as incarceration.
Okay, so she's incorrect about this again. Shocker. But I don't really totally blame her, I guess. So she is focusing on the trial court decision of Rosenblum v. Rosenblum and not the appellate court decision, which is the binding case law, not the trial court decision. So basically, the husband in this case submitted a petition to modify, saying, I don't want to pay, and he didn't pay in the meantime. And the incarcerated wife filed a motion for contempt, saying there wasn't a substantial change in circumstance and that he still had the ability to pay. The trial court said, boom, you're right, you should be paying. You're held in contempt. However, the appellate court reversed that contempt, saying that the petition to modify has to be seen first before the contempt motion. So the trial court judge erred and they needed to rule yes or no on the petition to modify, which based off of the rulings, they would have ruled no, but they just didn't do that first. And then you can hold him in contempt. So while they are bringing up the substantial change in circumstance, in that case, they're not using that as their argument for this. They're saying that case dealt with this contextually. It dealt with a husband filing a petition in order to not have to pay, and the wife trying to file one in contempt in the reverse. And their argument is, you cannot hold me in contempt before hearing this petition to modify. He submitted the petition in 2022. She's filed her contempt motion in 2023. His goes first. However, your criminal trial was set to go first. Or that's what Judge Dean said. That's why they said, we are going to pause all of this so that your criminal court case will determine how I'm going to rule on this petition to modify. Because I can't hold him in contempt in the meantime before I see this petition to modify. And you don't want me to see this petition to modify until you hope for a fool's chance that you can get out, or at least get a lesser sentence, which I would then have to consider when weighing modification options. But if you were sentenced to life,
Court sentences you to life in the Department of Corrections,
then that's not just a substantial change in circumstance, that's a permanent change in circumstance. When you were just in prison and you could have been in there for 15 years, that is a substantial change in circumstance. In prison for
life in the Department of Corrections
means you will never have the same bills that you had on the outside, so it makes absolutely no sense for him to have to pay you the same amount of money, or any at all.
The petitioner fails to present any clear or convincing evidence of financial hardship to prove otherwise in his pursuit to seek relief from his contempt and obligation of alimony, other than his unverifiable statement of being, quote, unemployed. His argument is legally and factually deficient without proper proof showing confirmation of such status in their attempts to delay the petitioner's payments and progress in this manner. In addition to court orders and Florida law, respondent has made numerous legitimate attempts to contact the petitioner while located at OCCD to inquire about her court-ordered alimony payments and concern regarding her son, vehicle, storage unit, bill payments, where the petitioner would repeatedly verbally abuse and lie to the respondent about promised payments, then tell her to, quote, call back, or, quote, call tomorrow, quote, don't worry, with the same answer and outcome each time she would cooperate with him for years.
And again, in her world, that's cooperating. Her berating him nonstop and him saying, leave me alone, call me back later, I don't want to talk to you. Because the thing is, she always says, you told me to call me back later. You told me to call me back later. I will bet my entire job salary he is not the one initiating that. I will bet that it goes a little more like this. I'm busy right now. Don't talk to me. I don't want to talk to you right now. Well, when is a better time when you're not so busy? Well, when can I call back to talk about my legitimate complaints and concerns? Well, when are you not as busy? We'll call back later. Call me back on Monday. Call me back whenever. I don't care. You told me to call you back and you still didn't do it. Why are you doing this to me when I am fully cooperating with you? Failing to realizing that berating him is abusive as all get out for just a broke leech trying to get more money from someone.
With your broke ass.
And taking money away from him, which is, you can argue is a financial hardship. You going to prison, him having to take on full responsibility of the child 24/7. He already was, in your mind, that's why you don't see any difference. You are solely living off of his alimony.
And does she or George have a job?
No. She hasn't worked for over 2 years. I mean, my alimony and stuff basically pays for where they live. So, I mean, they didn't need a ton, but, I mean, she was always calling to borrow money. And it's been like 2 years since she got a job. She keeps on telling me she's looking. She's always finding good opportunities and everything, but...
Brian, because I was supposed to have my son today to pick him up from school. Brian usually calls to make sure, hey, are you sure you're getting today? Because I've had job interviews.
When, in theory, you were supposed to use alimony, get your own job or own income or own resources, and transition to self-sufficiency. However, no. You did the exact same thing you did in that marriage, which was sit on your ass and neglect your child. And you didn't see an issue with it. So that's why you don't see an issue with him paying you free money now, because in your mind, it should just be the same. You were already supporting all of us with solely your income anyway. Why is there an issue now? The issue now is that his son will always come first to you, yet you want to come before your son. Even though in this, you always put your son in there. And it's just so, I don't get how she thinks this works on anyone when it hasn't, especially in the legal system. I call about my court-awarded proper lawful alimony payments, as well as concern for my son, and my storage unit, and my meals, and my this, and my car, and my that. The things that she actually cares about. Because the concern for the son is like a nebulous, abstract thing. That can be anything. You can be concerned for a million reasons. But for the car, for the storage unit, for all those other things listed, those are hard facts, very tangible things that can happen. Find out where X is. Find out where Y is. That is my true goal. Oh, and I have some concerns about my son. He's not loving me enough. Yet she's the one who is always verbally abused. That's the wildest thing to me every time. If you are being verbally abused, if you are being obliterated and destroyed by your former husband and son,
what's the point of me fighting for my life with my son when I'm treated the way I am by both of them? This is a form of mental and emotional abuse. Former husband encourages and enables it. I'm yelled at for everything. I'm afraid to call for fear I will be obliterated and brought to a new level of low, or try to see how hard I can be made to cry, then laughed at. I'm damned if I do and damned if I don't. If I do continue in my fight, which I will and am, I'm disrespected and almost destroyed. If I don't, then I look like the uncaring, heartless, incompetent mother person former husband is hell-bent on making me out to be. I just started speaking to my son from being screamed at with cruel lies and horrible, mean things that I will not repeat over nothing. I didn't call for 3 weeks because of the shock and pure hurt I am still in for what was said. I am made to feel like a chore, burden, and pest. I am not welcomed, like life is better without me. Everything is one-sided. No one listens to me. I have made the active decision to not call for an undetermined length of time so I can take a break from the beratement. I can only take the terrors inflicted by former husband in doses. Right now, I've gotten my fill from both of them. If my son wants to speak to me, he can write or schedule a visit, which I doubt will happen from the lack of encouragement and inclusion of me to have a relationship with our son by former husband. Please understand, I can only take so much on top of everything else. I love my son. I need my son. Just not this version. Not right now.
leave them alone. Not a single solitary soul is forcing you to call them. Not a single one. If y'all were still married and all of your bank accounts and everything was still tied into him, cool, I get it. You have no other options. Y'all are divorced. Just because you spent 2 years of your own life, your free life, separated from him, still being a succubus, just absorbing and sucking all the resources from everyone around you, does not mean they have to play that same game when you're in prison. And you're used to being able to tell anyone, here's this man, he abused me and made me feel bad and horrible. Now punish him and reward me. And unfortunately, in her life, that has worked more times than it hasn't. And now that she has been exposed as the true abuser that she's always been, she is shocked that those tactics do not have the same effect.
Both parties were fully aware of the final judgment was in effect, especially and foremost after the judge verbally reiterated in court, ordering both the petitioner and his counsel to continue payments in the case management conference on September 19th, 2022. The petitioner still refused to be inconsistent in any amount of payment, and the respondent, being indigent with a growing negative account balance, filed her motion for contempt to make the judge aware of his violations and willful disregard for the agreements and court orders. The respondent's need of essentials were not being met by the facility, and her outside responsibilities were in jeopardy, which could and should have been fulfilled and saved would the petitioner have been making payments as ordered. The petitioner and his counsel unilaterally made the decision to stop her entitled payments, completely avoiding the court, due process, and her active legal right to alimony. Their actions are not only unjust, but undermine the capacity and authority of the court with its legal protections that are to reinforce and ensure rules, fairness, and support.
And what exactly is fair about you trying to take $67,000 away from your child's household and given to an inmate behind bars for murdering someone? Is that just? Is that fair? That's why it's so annoying like when she's saying, I just can't believe the judicial system is so unjust and won't protect or help people like me. You mean murderers? You're not this helpless, abandoned thing. You are a vicious, cruel, abusive person who killed someone. Whether you meant to do it or not, you did it. And now you're mad that you have to face the consequences of your own actions.
Well, if it isn't the consequences of my own actions. What's up? What's up?
And because you can't conceptualize of that, every time these consequences come forward again and again and again, because in your mind, you feel like it should be over. Why does it keep happening? Oh, trust me, every single aspect of your life will blow back with a consequence that you haven't even faced all of them yet. But it's going to keep going because that's what happens. And this is another one of those consequences. You will lose your support.
You're a fool, and you will lose everything
that you think that you are rightfully, court-ordered, justly entitled to, and you will lose the power and control you had over your son. These are just extended consequences of taking a father away from his children, of making sure that his children never have a relationship with their father, that they don't get to grow and rebuild their lives special and have those connections and see those beautiful horizons you keep trying to flaunt and throw in the judge's face. Don't worry, I have a whole life worth living. And that's how she was since the interrogation. It's always been this idea of, okay, I get it, you all are upset and this is serious, but he's dead already. I'm not. My life is still worth living. I'm still here. Me. He's already gone. Why are we still talking about it? Don't you know I feel bad already? Are you trying to make me feel worse? Why are you bringing up his kids? He's always talking about his kids, and now you want to remind me that I killed their father?
You know what? I'll give you 5 minutes or so in there. I'll give you 5 minutes or so.
5 minutes for what?
To be honest with you, I don't know.
Were you punishing him?
No. Just...
Well, that's what you're saying in the video.
This is what you got. This is what you make me feel like.
See, and then it's all backfired on me. Like, it's all backfired on me. And I understand the severity of this.
Yeah, he's dead.
It's awful, I know.
Okay.
It's awful. And I will tell you both this right now, too. I will never drink alcohol again.
Okay.
Like, I will never drink alcohol again. I don't care what it is in any way, shape, or form.
But let's get back to this.
In itself, for me to have to live with getting him out and doing what I did is punishment enough. I think that's why I haven't slept, because that's all I see. So that right there says something. Not my intention. Nonetheless, I have to live without him now.
Yeah.
Nonetheless.
Yeah.
Punishment in itself. I am through with alcohol. And it's unfortunate that stupid things like this happen.
Mm-hmm. Absolutely.
Nonetheless, I have to live without him now.
Mm-hmm. Yeah. His daughters, too.
Are you trying to make it worse?
Sorry, what?
Are you trying to make it worse?
Make what worse?
How I feel?
Kicks the door open 4 times, and then what? And then what happens?
He's always talking about his kids.
I'm, pardon me for saying, a and a bitch, and not a mother.
Okay.
I'm just trying to sleep.
Okay.
So, feed the beast. Go downstairs. That's after this.
So why are you leaving that out? You're not telling me how that happened. Again, that's like the third time you've done
I
that.
don't know what you want me to tell you. He got on top of me and punched me in my
That's
ear.
what I want you to tell me.
Yes.
And I've asked you like 4 or 5 times.
Okay, well, I didn't know you needed that specific.
You didn't even include it at all.
Me and ear. I saw white.
That is so abusive and unfair. And honestly, that's how she would frame it, and has framed it. But just a mess. She keeps saying this verbal order from September 19th, 2019, which is not what he said. He made the order temporary, which just put everything on pause. But she also sent that letter at the time, buttering him up, saying, "Oh my gosh, thank you so much for being heard. Dear Judge Dean, I wanted to take a moment to thank you for allowing me to be in attendance during the case management meeting last Monday, 9/19. It has been such a long time since something good and real has happened to me since being incarcerated for ongoing 3 years almost. I thank you profusely for helping me, listening to me, and having an open heart and mind to see me as a human being, a mother also. Your invaluable time, empathy, and understanding are beyond appreciated. Thank you for seeing me. I am so impressed, and my sincerest gratitude cannot be fully expressed for your kindness and goodness. I look forward to any future meetings there may be, and am confident my hard work, determination, and efforts will not return to me void or fall on deaf ears. A victory indeed in my battles in preparation for the war on the horizon. I will not creep away as I continue to be brave and fight on. Thank you for giving me hope more than you know. It was an honor to meet you. Your honor. As sorrowful, yet always rejoicing. As poor, yet making many rich. As having nothing and possessing all things. 2 Corinthians 6:10. P.S. Thank you for seeing that crystal balls don't work at all, ever. Dust catchers. Sarah Boone. Because the truth is, she just went on rambling and ranting, and that's why he said, number 8, the respondent had made herself known or advised that she was upset about not being informed. 7, the court cannot hear the respondent's motion for contempt regarding unpaid alimony until after a final hearing is held on the respondent's petition for reduction or elimination of alimony. See Rosenblum v. Rosenblum, which reversed a trial court's contempt order because it was issued before the modification action was heard. 8, the respondent expressed frustration at not having matters heard and not being adequately informed about her case. 9, the court explained that the family case is on hold pending the outcome of the respondent's criminal case. 10, the court finds that permanent decisions regarding relocation and alimony should be postponed until the adjudication of the respondent's criminal case, so that circumstances are clearer. 11, the respondent was informed that she may opt for a final hearing on the petitioner's petition for alimony reduction elimination and her own contempt motion, but that the court would have to consider her current status of incarceration when making determinations. That means she went on a diatribe that she just tried to throw all of this in there, and the fact that he didn't grant Brian's motion meant that he granted hers in her mind. That's not what actually happened, but because she didn't lose, she won. And now is requiring you to treat her as such. And again, the knife cuts both ways. If she keeps trying to say, give me these records, I need to know all your finances, they're going to ask for yours too. They're going to say, how much have the Delphines, I think that's their name, given to you? How much did Lana give to you? How much have all these people given to you? So when you submitted your financial affidavit and put 0 across the board, you were lying, correct? Because you didn't outline that. You didn't outline that you've received thousands of dollars from your supposed alleged fan throughout the years. But Brian didn't prove to you that he was unemployed through clear and convincing evidence. What does that mean? It's the easiest thing in the world to prove. Were you fired from your last job? Yes. Okay, that checks out. Do you have a new job? I don't know if he has a new job or not, or if he's self-employed, or if he's, an independent contractor. But if he is not formally employed under a corporation or employer, then he can probably roll with that. But if he's doing some independent contract work that doesn't have an official employment contract, yes, is that a workaround? And yes, should he disclose that in an ideal world? But it's not the same as he has a full-fledged job and is just lying to you and saying he doesn't. Even if he did, still not that important, because that's not the key issue at hand, even though she wants you to believe it is.
Case law. Resolutions. Respondent respectfully requests the court to 1. Grant her motion for contempt for lawful reasons stated in this pretrial memorandum, denying the petitioner's motion for continuance and termination of alimony, as his argument lacks legal merit and does not justify noncompliance with active court-ordered agreements and inactive modifications. This has caused the respondent unnecessary financial hardship and loss for over five years, with his ongoing unlawful withholding of her entitled alimony payments to prosper in her current circumstances, this family law matter, and her life as a whole. 2. Enforce the alimony order in the final judgment and underlying marital settlement agreement. 3. Compel petitioner to produce evidence of permission from the court to reduce or terminate any alimony payments to the respondent. 4. Impose appropriate sanctions against petitioner and his counsel for filing a baseless motion to continue, unnecessarily delaying proceedings and the respondent's lawfully owed ordered payments to rightfully thrive in her life, needs, and responsibilities, regardless of her status and location. 5. Impose further sanctions to petitioner for failing to obtain legal modification granting formal permission before ceasing ordered payments to the respondent. You hear this? It's just punish, 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 punish. This is exactly the shit she was doing to George. I have had it. You have taken me to this. I will punish you to the fullest extent that I can. And if I can't do it, I'll get someone else to. And every time it blows up in her face, as it should. Page 5. E. Personal property. Please also refer to respondent's filed financial affidavit. A. List all personal property to be divided. 1. 2011 Kia Sorento. 2. Personal storage unit. B. State the suggested disposition of such property. Immediately upon the respondent's incarceration, petitioner took possession of her vehicle directly from the sheriff's office and secured at the marital home. After verifying the placement and safety, he verbally promised the respondent to manage, and both parties mutually agreed upon him taking full responsibility of her property while her case was in progress. Petitioner also proposed and coordinated a storage unit where her belongings from her old townhome were placed and secured. She repeatedly inquired about her personal property from the petitioner to ensure protection during, including setting up other arrangements at no cost in case the petitioner refused and discontinued to cooperate in paying his obligated alimony to cover. Petitioner would continuously tell respondent to, quote, not worry, quote, I've got it covered, quote, nothing is going to happen to them, quote, it will be taken care of. When she would ask for a status update to make sure he was really doing as promised to save her last ultimate resources and generational legacy to share with her son. The way you use that boy is so annoying and aggravating. He doesn't want shit you have to give him. Can guarantee. Respondent felt the petitioner was being untruthful after not receiving any updates other than the aforementioned for years, and coordinated turnover of her vehicle's keys, locks, and keys for storage with information to be given to her brother, who lives locally, for safekeeping and to provide relief for petitioner, peace of mind for the respondent. After concerned repeated efforts and no-cost solutions by the respondent to acquire her personal property, keys, etc., Petitioner finally stated, quote, "The keys were lost in the mail." Since this last statement made by Petitioner, respondent utilized her outside resources to locate information for this case and possibly filing an unlawful disposition suit against him, found out her vehicle was scrapped, junk salvaged, and storage unit auctioned off due to abandonment. Respondent made every effort to save her personal property, provide answers, multiple solutions, and arrangements to the petitioner for these to be successfully taken care of and protected during her incarceration, after petitioner promised and continuously assured her would be. Petitioner had legal duty to return or inform respondent before disposing of or abandoning her property and should lawfully be liable for total cost and damages of.
He has absolutely zero legal duty for any of that. How many times does she just say he verbally promised? Who gives an F about a promise? I promised myself I wasn't going to buy gummy worms for the third time this week, but here we are. Unlike I don't regret it. And actually, you don't regret this either. But a promise doesn't mean anything legally. Where is the contract? Did he sign his name? Did anyone notarize it? Did you set up any kind of thing officially other than passively asking for him to take it over the phone? And if you did that, that is not a binding contract. That is you voluntarily giving your property over to Brian. He is not contractually or legally bound to your property or even to give it back to you. You voluntarily handed it over to him. Unless you have a phone call where he says, I agree, I will hold on to this for the duration of your incarceration or your court case, and then I will return your belongings. And then he's not on the hook for this. And she knows it. She's just mad. And this is just a whole frivolous claim as is. She wants to say he's filing frivolous claims. He or she is being like, I want to file an unlawful disposition suit. And I'm like, that is a vexatious, frivolous claim that the courts do not like. Courts do not like convicted killers continuously harassing their ex through civil court. Because that's the next step. After they lose in criminal court and they start to lose all their other rights, odds are other court cases come up because of that, especially if you have children involved. So you aren't the first person to get upset that they were sent to prison for life and then decided to take it out on their spouse and blame them for everything. Courts do not like this whatsoever. Especially when it would just be a waste of court resources, and more importantly, it shows your pattern of behavior that whenever you get an opportunity, the convicted killer wants to punish her victims. This does not paint the image of this loving, caring, compassionate mother who only wants to bring greatness to her son and everyone around her. This sounds like a bitter ex who's upset she didn't get away with murder and now has to suffer consequences, which includes her having to get her own money and having to deal with her own stuff, saying, I set up all these no-cost solutions, then 2 sentences later, I set up all these no-cost solutions in case he wasn't going to pay his alimony, which was to cover for it. Again, another cost that you just assumed the alimony was going to pay for. The alimony was going to pay for the storage unit, the paid lot, the lawyer, printing off the evidence, your essentials in the jail, stamps, envelopes, all the things, hot meals. You thought $1,000 a month was going to pay for all of that continuously because these are recurring payments. And you had the magazine subscription, the birds and blooms or whatever it is that you yelled at him for not refilling. At no point during anything that you mentioned in here does Brian actually look bad. You look unreasonable every time you admit, I called him to check on the status of because I didn't believe that he did this. Okay. That means nothing prompted this. You chose to go out of your way to harass this man again because you're locked behind bars with no job and all the time in the world, and he's telling you, I'm busy trying to work to take care of our son and raise our child, and I can't do that when you keep calling me every 15 minutes asking and begging for more money.
His ex-wife is bonkers. She was all over him all the time. Send me money, send me money, send me money. How can I send you money when I don't have a job? His ex-wife, when I say a monster, she's a monster. She like completely berates him about money, about the father that he is, what he did to her, all this other stuff.
Which is ironic because you think that those clips, she's talking about herself. Because that's exactly how she treats Brian. But she's saying that this is how George's exes were. That they were these monsters, and this, I can guarantee you, bet, again, my salary, I'm throwing my salary left and right like we have free healthcare or something. Anyway, I would put money down that they couldn't even be in the same orbit as annoying and abusive as Sarah Catherine Boone Paulsen.
Excuse me. You're eating.
But all she does all day in every single letter, every single motion, every single person she ever talks to is send me money, send me money, send me money.
Send me money, send me money, send me money.
Completely berates him about the father that he is, everything that he's done to her, a monster. And because she's known him for decades, she assumes, well, no matter what, I'm always going to be in your life. I'm the mother of your child. You can't get away from me. We were married for 13 years. I'm still wondering why to this day. So, can you please put some money in for commissary and more credits on the tablet? And then we come to the third-party resources again of, I didn't believe this, so I had my third-party representatives tracked down and it was scrapped. Okay. He should be legally responsible. No, you would have to go after the scrap people, if anything. The judge is going to completely ignore this, just like she ignored it the last time. And this is another Sarah-ism. She doesn't accept the first answer, and if you told her no, she just thinks, well, I didn't ask it the right way, so let me ask it again, and you'll say yes this time. Because I know that if you understand where I'm coming from, you'll agree with me and want to give me everything I ask for. So I'm going to repeat, where is my personal property?
What was the legal duty? She just says shit. She really does. He had the legal duty to return and inform. Says who? You haven't cited anything. You're just on vibes again. And didn't the judge already deny this stuff? Especially the personal property stuff. And now he has to be lawfully liable for total damages, loss. But also, you're wrong. It says, the way you phrased it earlier, made it sound like he auctioned off your storage unit. Now you're saying the storage unit was auctioned off due to abandonment, meaning he didn't do anything. He didn't ask them to auction it off. They did it themselves. Sure, if y'all had an agreement, notarized, written, he should have been taking care of it. You didn't. You're saying he promised, and your word means nothing after how many lies that you've told. And you like to say that he is committing perjury to the court and should be held responsible when that is all you've done. It's just, what are these costs? C, list the value of each item of personal property. 1, 2011 Kia Sorento, 7,500 miles. Website 1, certificate of destruction. Website 2, $8,400. Website 3, $7,993. Website 4, $7,580. Storage unit, based on estimated value of irreplaceable contents, including antique jewelry, furniture, unit as a whole, $10,000. She really wrote that whole sentence. She did. She wrote it and submitted it as if it means anything. We don't know what was in that storage unit. It could have literally been bags of shit. And you're telling me that it was antique jewelry, irreplaceable contents, just invaluable, priceless. But I guess if I had to eyeball it, around $10,000. If you had property worth $10,000, you would have sold it for more alcohol when you were free. Don't be cute. And that 2011 Kia Sorento selling for $8,400, Today, sure. But yeah, he can't be held responsible for your loss of property because you killed someone and couldn't take care of your property. You can say that he promised this, promised that all you want. If it's not written down, it didn't happen. So he didn't abandon your personal property in your storage unit. You did. You abandoned your personal property. You abandoned your Kia Sorento when you went to prison after murdering someone. These are intentional actions that all stem from you. So you can't say, hey, I know I did something horrific and they're forcing me in these cuffs behind bars for my life. I don't want to do that. So we just have to ignore that. And we have to blame you because you're out there and you can do what I want you to do. So you legally are responsible to, and you promised to. No. Resolutions. Respondent is requesting status and or return of her personal property listed above from the petitioner immediately. Return where? Return where? You're going to say to your brother, but that just complicates the whole issue even more. No, you can't have personal property anymore. Page 6, G. Attorney's fees and costs. Respondent continues to attempt to understand her position of defense against the petitioner and his request to charge her with his attorney's fees. As in the supplemental petition, it states, due to not signing their joint stipulation and in their pretrial memorandum, quote, resulting from the chaos created by the respondent's criminal conduct. Okay, so that's where she got the word chaos from. She's mad that they used it on her, so she's been using it in this again and again. I wondered why, because it just didn't fit. Whatever.
And actually, I think we're going to take a detour here because we've talked about it a whole bunch and it's relevant to all of this, and it kind of explains why she's answering the way she's answering, the words she's using, and the intensity in which she is using them, because they laid her ass out. So let's go and review Brian's motion submitted by Mr. Martell and see how he lit her up.
To former wife's pro se motion seeking enforcement of alimony, child support, sanctions, and attorney's fees. Comes now petitioner Brian Boone, former husband, by and through undersigned counsel, hereby files his response in opposition to former wife's pro se motion seeking enforcement of alimony, child support, sanctions, and attorney's fees. In support of this response, petitioner states as follows. 1. The parties' marriage was dissolved by final judgment on June 15, 2018, incorporating a marital settlement agreement and parenting plan. Under that judgment, former husband was ordered to pay former wife $1,000 per month in alimony for 84 months and $100 per month in child support. 2. These obligations were predicated on the expectation that former wife would care for the minor child during her time sharing and have financial needs outside of the marriage. 3. On February 25, 2020, former wife was arrested and has remained continuously incarcerated since that date. 4. She has exercised no overnight time sharing since her incarceration began. In fact, due to her imprisonment, former wife has been completely unable to care for, support, or spend any overnight time sharing with the child for over 5 years. 5. On October 25th, 2024, former wife was found guilty murder.
Will the jury find the defendant guilty of murder in the second degree?
And on December 2nd, 2024, she was sentenced to life in prison.
Ms. Boone, court sentences you to life in the Department of Corrections.
6. Since 2020, the former husband has provided the child with a stable home, covering all expenses for food, clothing, medical care, education, and other needs without any contribution, financial or otherwise, from the former wife. 7. The former husband's day-to-day life became that of a single parent by necessity. He ensured the child's emotional and physical well-being, while former wife, through her own actions, rendered herself unavailable to fulfill any parental role. 8. Despite her ongoing incarceration, the former wife, acting pro se from prison, now moves to enforce the original support orders, to hold former husband in contempt, sanction him for non-payment, and to recover attorney's fees. 9. It is undisputed that the former wife has had zero overnight time sharing with the minor child since her incarceration in February 2020. By being incarcerated, she removed herself from the child's life physically and parentally. 10. Florida law provides that a parent's lengthy incarceration, especially for a serious felony, is so contrary to the child's welfare that it can justify even termination of parental rights. See MSB v. RB. 11. The former wife has now been convicted of murder.
Guilty of murder in the second degree.
A heinous intentional act, ensuring that she will remain in prison for the entirety of the child's upbringing.
To life in the Department of Corrections.
12. Florida's public policy and laws strongly condemn violent criminal behavior, and a parent who is incarcerated for such misconduct cannot simultaneously fulfill the obligations or enjoy the benefits of an active parent. 13. From the moment of former wife's incarceration, the former husband had no choice but to step into the breach. He has provided the minor child with a loving, safe, and stable home without any assistance, financial or otherwise, from the former wife. 14. Equity should not punish the parent who stayed and fulfilled his responsibilities while rewarding the parent who abdicated hers. 15. The former wife's motion, however, seeks to do just that. She asks this court to compel the former husband to pay tens of thousands of dollars to her, despite her inability to contribute to the child's care in any way. The court should reject this request as it upends the purpose of child support and alimony under Florida law. Alimony arrearages claim. 16. Florida law is clear that alimony is awarded based on a recipient's need and the payer's ability to pay, and an award of alimony is not appropriate when there is no need for support by the requesting spouse. See Taylor v. Taylor, 17. Here, the former wife has no legitimate financial need for alimony at this time. By virtue of her incarceration, the state of Florida and its taxpayers is providing for her basic living needs, including shelter, food, and medical care. She does not pay rent, utilities, groceries, or transportation costs while in prison. 18. In other words, the primary expense alimony is designed to cover for a dependent spouse have been assumed by the government during her incarceration. Any incidental personal expenses she might have, commissary items, etc., are minimal in comparison to normal living expenses and are not the responsibility of the former husband. 19. The former wife's imprisonment is an involuntary lifestyle change for the family, but it was voluntary on her part in the sense that it resulted from her intentional criminal act. You better read her. 20. Florida courts consider such self-inflicted changes when evaluating support. For example, in the child support context, our courts hold that, quote, an individual's actions that lead to incarceration are voluntary and do not automatically justify avoidance of support obligations. See 21. The former wife's need for alimony has effectively vanished since 2020. The entire premise of the original alimony award to support her post-marital living expenses and transition to self-sufficiency has been undermined. She is not incurring those expenses, nor will she in the future, given her life sentence.
Life in the Department of Corrections.
22. Continuing to enforce alimony under these conditions would serve no support purpose. It would amount to an impermissible windfall or punitive transfer of resources from the child via the sole custodial parent to the incarcerated parent. Florida law does not countenance alimony as a reward or punishment. It is purely to meet the needs of a dependent former spouse, if such need exists. Here, they do not. 23. In Waskin v. Waskin, for example, a former husband's post-dissolution incarceration led him to seek relief from alimony due to reduced income. The third DCA invoked the clean hands doctrine to deny relief because his predicament was caused by his own voluntary actions. 24. The court held that equity will not relieve a party of an obligation when the, quote, decrease in the former husband's financial ability to pay, the requisite substantial change in circumstances, has been brought about by the former husband's voluntary actions. 25. While Waskin dealt with an obligor trying to avoid payment, the same equitable principle should apply on the flip side of the coin. A family court should not compel one party to continue paying alimony when the recipient's need no longer exists due to the recipient's own voluntary misconduct. 26. The former wife cannot come to this court in equity and demand that her former husband shoulder a financial burden that her own actions made pointless. Damn. 27. In summary, any claim by the former wife that she is, quote, owed alimony now is both invalid and inequitable. She has no current need for alimony support, and compelling the former husband to pay would divest resources from the minor child, effectively harming the child to create a jailhouse bankroll for the former wife. Florida's alimony jurisprudence does not permit such an outcome. Period. Child support arrears. 28. In addition, the former wife seeks enforcement of the $100 per month child support that the former husband was ordered to pay under the original judgment. 29. That provision made sense only in the context of the parenting plan then in place, when the former wife had significant time sharing and would expend funds on the child's care during that time. 30. Once the former wife was jailed and the child came to live full-time with the former husband, the entire logic of that child support arrangement was upended. From that point forward, the former husband has been the de facto and now de jure custodial parent, and the former wife, if the roles were properly realigned, would owe him child support. Period. This guy is eating her up.
Bon appetit!
31. Florida law does not excuse a parent's support duty simply because of incarceration. 32. In Wilkerson, the 5th District has noted that, quote, the duty to support one's children pre-exists other duties. It exists as a result of parenthood and came into force before any criminal conviction. 33. In other words, the former wife's incarceration did not terminate her obligation to contribute to the child's support. It merely made her unable to do so, for which the former husband and the child have become the consequences. 34. Over the past 5 years, the former wife has paid zero towards the child's needs. She has also failed to exercise the court-ordered visitation, for obvious reasons, and failed to partake in decision-making for the child. 35. These failures put her in violation of core aspects of the final judgment, which expected her to be an active parent, which one might argue she could not help being physically...
Okay, I am going to cut in here because in my screenshotting, I accidentally cropped this one. And at first I was like, oh, you know, maybe it was at the end, but no, the part I cropped out was actually very important. So picking up on that sentence, while one might argue she could not help being physically absent, the fact remains that this predicament was caused by her actions, and she has not even attempted alternative means of support. For instance, arranging for relatives to assist the child financially. Boom, that is a point that I haven't heard of, or I haven't heard of a lot, and I haven't really expressed a lot of. I've told her to reach out to her family and beg her family for herself so that she can leave Brian and her son alone. But I never even thought that she should have been reaching out to them to see if they can help her son.
36. The former wife is, in effect, in continuing contempt of the spirit of the parenting plan. She has utterly defaulted on her parental obligations. It would be grossly unjust for the court to enforce a financial right in her favor, collecting money from the former husband when she has given nothing in return, and in fact has created additional burdens for the former husband and child. 37. Even if this court were to determine that some portion of the accrued alimony or child support technically remains enforceable, equity demands a set-off for what the former wife should have contributed, but didn't, to the child's care. 38. Florida courts have held that although child support is for the benefit of the child and not a debt between parents, an equitable set-off can be applied in where one parent owes child support arrears, but the other parent also owes a support obligation. And, quote, compelling equitable criteria and considerations justify an offset. See Suarez v. Suarez, 39. Here, the equities overwhelmingly favor a complete offset. 40. The former wife complains of $6,100 in unpaid child support, money that would have been paid to her, not directly to the child. But the former husband has spent far more than that directly on the child's needs since 2020, effectively covering not only his own share, but the former wife's share of support. 41. The former wife, if roles were reversed, could have been obligated to pay significant child support to former husband for the past 5 years, obligations she has not met. 42. Thus, if the court were inclined to enforce any arrearage on the original support, the former husband respectfully requests that the court apply an offset in the full amount of the former wife's unfulfilled duty to support the child. 43. The compelling equitable factors here include 1. The child has been exclusively supported by one parent while the other was absent by her own doing. 2. Any money paid to former wife now would not go toward the child, but likely toward former wife's personal commissary or other expenses unrelated to the child. And 3. Former husband has incurred all child rearing costs without contribution. 44. This is precisely the type of scenario where an offset is warranted to prevent unjust enrichment. 45. In practical terms, an offset here would likely zero out any claim former wife has for unpaid alimony or support. 46. Finally, it bears emphasizing that the child's best interest would not be served by taking money out of the household that actually raises him, the former husband's household, and funneling it into an incarcerated parent who cannot use that money for the child. 47. Florida's child support system is designed to benefit children, not to enrich one parent at the other's expense.
I want to see the receipts.
The court in Suarez observed that, quote, child support belongs to the child, even though the right to receive such support on the child's behalf vests in the payee parent. 48. Here, the child support in question effectively belongs to the child's household, which is with former husband. The child has in fact received the benefits of those funds directly from former husband. To remove those funds now and send them to former wife would be to take them away from the child. Such a result would contradict the very purpose of support orders. 49. In conclusion, the former wife's claims for enforcement of support ignore the realities of the situation and the equitable powers of this court. The court should deny any relief for alleged arrearages or unpaid support. 50. If any arrear is recognized, the court should find that it is fully offset by the support the former wife failed to provide and by the extraordinary expenditures and sacrifices made by the former husband to raise the child alone. 51. The former wife's one-sided accounting, demanding every penny of support from former husband while acknowledging no corresponding obligations of her own, should be rejected. Equity, fairness, and the child's best interest all compel the court to refuse enforcement of the original support orders under these unique circumstances. Unclean hands and attorney's fees. 52. The former wife comes to the court with unclean hands,
You nasty.
a prerequisite for receiving equitable relief, including an award of attorney's fees in a family case, is that the requesting party has acted equitably and obeyed court orders. 53. The former wife, however, is in continuing contempt of the final judgment's time-sharing and support provisions. She has not exercised parenting time, not co-parented, and not contributed to the child's needs as required. 54. While her incarceration may excuse physical non-presence, it does not excuse the willful disregard of her parental responsibilities. By committing the crime that led to her imprisonment, the former wife effectively willfully violated the parenting plan's fundamental assumption that she would be a present, law-abiding parent to the child. 55. The court in White v. White noted that a party who has not made a good faith effort to comply with court-ordered obligations, there the husband failed to pay alimony and provide insurance, comes to the court with unclean hands,
You nasty.
and may be denied relief. 56. Similarly, here, former wife's hands are unclean.
Little nasty.
She has not, quote, done equity toward former husband or the child. Equity should therefore bar her from recovering attorney's fees or any affirmative relief until she has purged her own defaults. 57. It would be fundamentally unfair to reward former wife with fees or to sanction former husband when she herself has flouted significant obligations under the very same final judgment she seeks to enforce.
Yeah, double homicide.
Bitch.
I'm sorry.
58. Florida Supreme Court has made clear that trial courts may consider a party's conduct and the, quote, circumstances surrounding the litigation when deciding attorney fee requests in family cases. 59. In Rosen v. Rosen, the court held that while need and ability to pay are primary factors, the court may consider factors such as the merits of the parties' positions and whether the litigation is being used to harass or frustrate. That part. 60. The court specifically noted that if an action is frivolous or brought in bad faith, the trial judge has discretion to deny attorney's fees to the offending party. 61. Here, the former wife's position and motion is frivolous given the reality of her situation. She seeks to enforce rights that have been effectively lost due to her own wrongdoing, and she makes inflammatory accusations, e.g., quote, parental alienation, against former husband who has simply protected the child from trauma. 62. This is precisely the type of scenario where the Rosen decision would allow the court to deny any fee award to the former wife, regardless of financial disparity. 63. Further, imposing fees on the former husband would likely detract from the resources available to support the minor child, again harming the innocent to reward the wrongdoer. 64. Even if the former wife could show some need, the former husband simply does not have the financial ability to pay her attorney's fees. He is a single father
Works 2 jobs, who loves her kids and never stops, with gentle hands and the heart of a fighter.
supporting a household on his own. Any income he earns goes to rent, groceries, childcare, school supplies, and the like for the child. Meanwhile, the former wife's living expenses are paid by the state. 65. In effect, former wife is asking the court to order the family's scarce money to be diverted from the child's upbringing to pay lawyers to litigate on behalf of a mother who is in prison for murder.
Yeah, double homicide.
Bitch.
I'm sorry.
Such an outcome would be inequitable in the extreme. Florida's fee statutes is intended to ensure both parties have similar ability to secure counsel, not to oppress one party or subsidize vexatious litigation. 66. Given the entirety of circumstances, including former wife's egregious conduct and former husband's limited means, the only equitable result is to deny former wife's request for attorney's fees and costs. 67. Moreover, to the extent former wife seeks sanctions against the former husband or his counsel, this response emphasizes that there is absolutely no legal basis for such sanctions. 68. Former husband has acted within his rights by seeking modification and by caring for the child. He has not violated any court order in bad faith, and any claim asserting that is without merit. Wherefore, petitioner, former husband, Brian Boone, respectfully requests that this honorable court deny the former wife's motion in its entirety. Specifically, former husband prays for the following relief. A. An order denying former wife's request to enforce or collect any alleged alimony arrearages. B. An order denying former wife's request to enforce or collect any alleged child support arrearages from former husband. C. An order denying former wife's request for sanctions against former husband and his counsel. D. An order denying former wife's motion for attorney's fees and costs. E. Such further relief as the court deems just and proper.
So yeah, that's why she's so mad and hard pressed right now, because he ate her up and told her what she needed to hear way before this time. But it wasn't until reviewing that I realized, or that I remembered, She was the one who asked for attorney's fees first. So out of all this, she asked because he's not paying alimony, he needs to pay attorney's fees, even though she doesn't have an attorney or fees to be paid. Just the overarching in general, pay me money so I can pay for an attorney. She's not even putting out figures or anything. At least Brian's lawyer has billable hours and has been keeping track of every single thing he's done for him. But she put it in motion, so the lawyer had to respond. And so that's what I mean by he's going to respond to each one of these frivolous claims that she throws out there because she's trying to sound smart, she's trying to get her jabs in, and she's trying to make him look as bad as possible. And it really will blow up in her face. Do you see how he incorporated case law? He didn't just put it at the bottom and said, here's the case law, but it's actually within the document itself, clearly painting the picture. This case showed this, and it relates to this case like this, so we should do this. Meanwhile, here it is just nothing but heavy opinions, accusations, solicitations, and just beratement. And then case law at the bottom being like, just trust me, I'm right. But with that refresher, we can now go back into her current mess. And this is how she responded to this motion, because also Brian never responded to any of the text messages. We know this. And he barely answered her calls, only when he had to. So she has never received a formal response from him to any of her claims. So then when his lawyer submits this, she loses her mind and she can't let it go. And she can't let those little words go. His actions are intentional and deliberate, and the chaos, he's the only one causing chaos here, not me. I'm perfect. And actually, all of this is Brian's fault because he forced me to call the police. I wasn't planning to call the police all day, which is why I ignored him.
What did you advise her to do?
I told her she needed to call 911 and that I would come over as soon as I could.
Did she call you again while you were en route to her residence?
She did. She called to find out if I was still going to be coming over.
And when you spoke with her while you were en route, what, if anything, did you advise her?
I told her she needed to call 911 and told her I was on my way, but she needed to get somebody over there.
Tell us what she told you when you arrived.
George was dead, and once again, I don't remember if she told me now or before that they had been playing hide and seek and she fell asleep, but I, at that time, told her again she needed to get 911 called to get somebody over there.
Had she called 911 at this point?
No, she had not.
So you've advised her now 3 times to call 911?
Yes.
But no, I had to answer the call because he wouldn't leave me alone because he's concerned about our child or whatever. And then he's asking me to call the police because I killed someone. That's why we're here. I wouldn't be surprised if she's literally had that conversation of, if I didn't pick up the phone call from Brian that day, I could have figured it out and I would not be here right now. Now that is purely projection from my end. Okay, well, that wasn't just my projection, that was Paulina's projection too. I'm glad you agree.
1. The petitioner and his counsel did not ever, quote, attempt to come to a resolution on these issues with the former wife without the necessity of filing a contested supplemental petition for modification, as stated, nor, quote, the former wife would not sign the joint stipulation which resulted in the filing of this action. This supplemental petition to modify was received via summons to the respondent with no other correspondence or notice of any kind provided prior, as suggested, to avoid any presumed cost incurred from this filing by the petitioner. To clarify the untruths for the court to fully understand their self-inflicted costs and confusion, the timeline is as follows. Okay, I'm gonna have to pause before I take this on because there's a lot. But she's saying that his attorney's fees are self-inflicted. That's not what that means when you're getting the other person to pay for your attorney's fees. That's, you winning. I win, and on top of that, I'm asking you to pay my attorney's fees for forcing me to go through this in the first place. And so, yeah, he's asking you to be held accountable for attorney's fees in order to offset this alimony bullshit. So not only have you not paid child support yourself, despite not contributing a dime to your child's upkeep, you're saying that the alimony, if you were given the alimony, then you would buy gifts for him on the holidays and that would constitute you supporting him? No. You have not paid for him or supported him financially in any way since you were incarcerated, and you haven't even tried to. Yet you're demanding money from the only parent who is financially, emotionally, physically supporting the child. And she's saying the petitioner's counsel did not ever attempt to. Yes, they did. They reached out to you asking you to provide dates. You decided to be snarky and said, before I even consider thinking about providing a date, you need to answer my 7 questions and requests. Mr. Martell, I am in receipt of your letter requesting a date to be set for former husband's petition to modify. As said in my previous letter, no one has a crystal ball. I do not know 4 months in advance my location or status, making it impossible to determine the best date to choose from which you have proposed. 1. What are the requirements under Florida law stating a mediation needs to be scheduled for the petition to modify? Please provide documentation so I can understand the practices, procedures, and protocol for this area of family law. I can also have a general timeline of what to expect if possible, other than a letter from your firm telling me what I have to do. 2. Please provide copies of all documents to be discussed. 3. Please send contact information and credentials of the selected mediator and how was she selected. 4. Who all will be included in and during this meeting? 5. Who is the judge overseeing this case? 6. Is there going to be an agenda for discussion? 7. What if selected date has to be changed? Will I be penalized? Rescheduled? 8. Is the point of this mediation to try to force me into signing or agreeing to the only terms available presented by former husband? 9. What if I do not agree? 10. How is a video conference scheduled? As said, I do not know what date is best for me. By answering and explaining further the aforementioned concerns and questions will most definitely assist in my decision making. Your expedited response is greatly appreciated, as well as providing all requested documents and information. That is asking for legal work to be done, which costs money. That would require you to pay attorney's fees. If he did actually fulfill these requests and actions, I would absolutely charge you for those fees. They were your requests that we fulfilled because you asked for them. Now you got to pay for them. But they're not going to do that. They're just saying, I don't work for you, so who even are you? I told you this was us, me extending this to you. This was that notice of me trying to extend that olive branch. And she's saying, but you didn't provide any other kind of notice prior as suggested. Suggested by whom? By what? Where? And even if they didn't, it just says suggested, not a legal requirement. You were still given the opportunity. You refused in a snarky ass response. And now you're mad that they said, fine, we're taking this to court because we're not dealing with this back and forth all day, every day. So now she's just offended. How could you even consider charging me for an attorney? Don't you know I'm poor and I'm incarcerated and no one loves me and woe is me? It's so sad to be me. Why would you keep penalizing me further? Because you earned it. Because you keep doing stuff like this. This is wild to me. This is wild. After everything you've done since your incarceration in 2020, all of the hate you've received, all of the publicity, all of the notoriety, all of the help and support from people that you don't deserve help and support from, you have not learned anything. These are the same exact behaviors you have had since the first body cam footage we ever saw from you. No growth at all. ever. That's wild to me, but I need to take a break.
It's not easy for me to admit that I've been standing in the same place for 18 years.
Well, I've been standing with you. I've been right here with you, Troy. I got a life too. I gave 18 years of my life to stand in the same spot as you. Don't you think I ever wanted other things? Don't you think I had dreams and hopes? What about my life? What about
Miranda? I was waiting for Miranda to come in there and nobody came in there. I was waiting for her. That's right. Ain't nobody Miranda me. Miranda wasn't even in the room. Excuse me?
Excuse me.
We were fighting for our lives, Your Honor.
You're eating my peach.
The timeline is as follows. A. February 18th, 2022, supplemental petition for modification of final judgment, generated by petitioner's counsel before Joshua Martell, signed by the petitioner Brian C. Boone. B. April 12th, 2022, summons sent by Martell, a process server for scheduled delivery to respondent, includes documents A. Notice of appearance as counsel Joshua Martell, B. Supplemental petition for modification, served 2 months after originally signed by petitioner, C. Joint stipulation for modification, D. Uniform child custody jurisdiction affidavit. C. April 21st, 2022, summons received by process server to be delivered to respondent. D. April 22nd, 2022, summons and inclusions for delivered to respondent at OCCD. E. May 1st, 2022, respondent's answers to summons sent to petitioner as instructed. F. May 16, 2022, respondent's answer filed with the court by petitioner. G. July 5th, 2022, petitioner's correspondence attempt with respondents, quote, to schedule a mediation for our petition to modify as is required under Florida law. H. July 17th, 2022, respondent's answer and transparency to correspondence in confirming her want of participation with concerns. I. July 26, 2022. 1. Motion for dispense mediation, filed by petitioner claiming, quote, the respondent is refusing to coordinate a mediation at this time. No hearing held for this motion. Respondent not included or able to defend herself against another, quote, refusal accusation made by the petitioner and his counsel. The petitioner is accusing the respondent of refusing to sign their joint stipulation, which was served on her over two months after it was signed by the petitioner with a previous attorney and nothing attempted to do with before. His counsel made false statements in their supplemental petition, page 37, and to the court for the reason the document was generated, which was before Martell even became the petitioner's counsel, and before the respondent received the physical copy of to read, review, etc. The joint stipulation was sent the same day in the same summons with the supplemental petition to modify and petitioner's notice of appearance of counsel introducing Martell. No joint stipulation was ever sent to the respondent before the petitioner filed their supplemental petition to modify, giving no opportunity for her to, quote, refuse signing, quote, which resulted in the filing of this action as libelously claimed. Because of their untruthful statement, also an improper handling of these documents, the joint stipulation foremost not being received by the respondent prior to their supplemental petition to modify, her right to mediation was forfeited, which has been avidly and emphatically sought by her since the beginning of this case. Would the joint stipulation have been received prior by the respondent for collaboration and review, the supplemental petition to modify would not have been made, causing a ripple effect of violations of her due process and constitutional rights. The respondent was never given a lawful opportunity to participate appropriately, as with many other missed opportunities caused by the petitioner and his counsel's undeniable wrongdoing against her throughout this case. Oh my gosh, I tried to just keep going, but I can't. This is so messy.
And a quick cut in before my original reaction because it's just so annoying. But the insinuation that if she was given the joint stipulation beforehand to collaborate, then obviously the petition to modify would never have happened. When that's not true, because you like to nickel and dime everything. And if you were just as difficult while trying to, quote, collaborate on that joint stipulation as you were when you couldn't even collaborate one-sidedly and choose a date that they gave you free reign to choose from, then odds are this was always going to end this way anyway. And the joint stipulation and this mediation was more or less an olive branch to see if you could do this. But based off of the text and based off of the way you said Brian has always treated you, he always was prepared for this to happen. And it was just a matter of time. And you didn't take any of the warnings seriously, just like you didn't take them seriously with the plea deal, and you thought everything was just a back and forth joke that you could collaborate, and that she was mad at Miss Cashman Esquire for not collaborating her and getting her the best plea deal of her entire life.
And her telling you to encourage me to take a plea deal? Who the fuck is this woman? She's never said anything to me about any of this, but does you and threatens me through you with life in prison if I don't take whatever it is they're supposedly working on together and not with me. OMG, for every person I've known in here, to have her as their attorney has either fired her or gone against what she tells them because she lies about everything, which I told you about already. Perfect example. My friend who was in here with me for 4.2 years and had her for her attorney hated her. The attorney kept trying to get her to sign for 10 years probation and going to program for 2 years. My friend said no over and over and kept holding out. She went home 2 weeks ago with all her charges dropped. This bitch kept threatening her with prison time too. And you see what happened?
Yeah, but her charges weren't second-degree murder, because that was her friend Christina.
Christina! Christina! Christina's gone. Your little tramp didn't leave any money to pay her, so she left. Just like your little slut.
And I'm pretty sure she had some human trafficking charge and some, Lady of the Night charges, potentially. And then there was like a technicality with someone else because she was connected to someone else's case or something. I just vaguely remember hearing this. And so her charges were dropped because of that. Not because she was actually innocent or that she made the sound legal decision. She kept holding out and then the circumstances aligned in her favor, but that was not the smart decision. And she thought the same thing would happen to her. Everyone would just forget about George's death and all her charges would be dropped and she would go home. So it's that attitude that has led her to this situation where no matter what she's offered, how many chances she is given, if it's not what she wants and it wasn't decided by her, she will spit in your face and then say you abused her. So you're contradicting yourself. You're saying up here, somewhere up here, that you were never notified about this mediation before the supplemental petition to modify. We've gone over this so many times and I've already played it, but it is you were given the opportunity to give dates. You chose in the longest unnecessary letter possible to be as unruly and uncooperative as you possibly could be, and then shocked when they want to leave and claiming, I haven't fired anyone. Everyone wants to always blame it on me. I was always ignored and in the dark. So much, I prepared an 8-page packet for Judge Wayne C. Wooten to provide during both court dates defending myself against my attorney's untrue, unresearched withdrawals. No one asked me nor permitted to speak my truth. To help him and the court understand my real concerns, along with the carryover since day one. I was trying to avoid going through any of this again going forward, in hopes he would listen and appoint a more suitable, experienced one accordingly, to save time for everyone to progressively move forward. He must have been throwing darts at a dartboard, blindfolded. This attorney, number one, is untrustworthy, unreliable, unprofessional with poor leadership skills, and is extremely unorganized. He was unable to perform ethically and as an adult, ignoring his client, misleading and deceiving. He didn't even respect me enough to speak before his withdrawal to try and remedy or figure anything out to stop.
I was totally blindsided because of the magnitude of his ineptness and dereliction of duty as a result, withdrawing from my case at the 11th hour after taking over 2 years with nothing I knew of but disappointment. I could have reported him to the Florida bar for legal malpractice, exhaustion 1. From my perspective, am I surprised my attorney is trying yet again to give up completely? No. Is it a blessing? Yes. Let's be honest. Frank J. Bankowitz is a dud of an attorney. He is unprofessional, hides, lies, and is disrespectful. I had a feeling when other attorneys spoke about him, winced, sighed, rolled eyes, saying they have some of his clients. And after finding his 3 public reprimands, I announced to the court, and which he said pissed him off being the reason for his first attempted withdrawal. This was going to be an adventure, but nonetheless, hoped for the best. Unfortunately, I seem to have gotten the worst. Thankfully, there are many other professional and scrupulous, valiant attorneys still available, and hopefully after all my previous letters and 6 withdrawals to date, not by my choice, Judge Wooten, you will remove the blindfold this time when throwing your darts of justice at the remember everyone has constitutional rights and should be treated fairly dartboard, and you wear glasses. So let's go for the bullseye. Please. Thank you in advance for hopefully caring this time. My case equals bizarre equals unknown equals different equals ignorance equals misunderstood equals unfair. This does not mean my case can't equal success. As always, my attorney did not listen nor care after I repeatedly tried reminding her of my unsecure environment, barking at me, I can listen or not. Still going, over speaking and not at all allowing me to respond. After repeating to her over and over and over while she's beginning to speak louder and over me still to please schedule an in-person meeting where all can be discussed further privately with no success of being heard, I disconnected the visit telephonically. She uncooperatively. She is impossible. See previous letter or ask her for a copy of the 2 I sent her. I was trying to remedy or lessen before sending this to you. Your honor. And not having to include. Now it's a race to the pulpit. My question, please, who acts like that and still be able to call themselves professional? She, like other former attorneys who always blame their dysfunctions on me, said, you don't like the answers I give you. What answers? See pages 1, 2, and 3. I am not the problem, except I want to and should be treated fairly, with respect, acting more professional than the paid. I've been doing this for over 40 years, professional. After so long and in all the experience, common courtesy, customer service, and listening skills should have been acquired. All attorneys, do you remember why you even wanted to be one? Remind yourself. No one listens, and it works for everyone's favor but mine. That I am a murderer, stuck in jail so they can pin on me. They're uninterested, unmotivated, hopeless. They're going to believe me over her haughty attitude. I am not wrong for not thinking less of myself, because everyone else has and does. This present attorney foremost. The justice system expects me and other inmates, aka clients, to accept its subpar, nonchalant, hypocritical, next on the list attorneys they keep aimlessly throwing darts for, malappointing, praying they don't withdraw. I have not fired any attorneys appointed in my case. For me expecting the highest equal standards possible, for wanting the absolute best outcome in my preposterous, mismanaged case, and representing myself is not an option, as both judges have now threatened me with. from being outspoken and intelligent in all my observations of the ongoing abuse I am and have experienced. I have no new experiences from it, always being the same blame Boone. I refuse to be moved in wanting respect, no matter who everyone thinks I am. Clarity, inclusion, honesty, and professionalism.
You did not listen to me in any way, shape, or form in order for me to explain myself better so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
Everyone wants to always blame it on me. And she wants it to be seen as this overwhelming injustice when this is just what happens. And you have to be ready for the consequences of not being participatory. Like I said a million times, if in that letter you had said all of that and proposed some dates, then you have enough evidence to say I was cooperating. They're mad at how I responded, but I was cooperating. You refused to cooperate unless they fulfilled all these tasks for you, tasks which you were not going to pay for and were going to force the petitioner to pay for if they were to get done. So instead of the petitioner paying their lawyer to do 7 of your requests, he did 1 of Brian's requests, which was to just cut all of this and go straight to trial. You are not entitled to mediation, especially after killing someone. Most people would go straight to trial to cut your parental rights immediately. He was trying to allow you to have a life with your child, to remain a parent, and to still have that connection. But you kept pushing and pushing and needling and needling and guilting and guilting, berating, asking and ordering and ordering. And then are shocked when they finally throw in the towel and say, we're done with you. Respondent was never given the lawful opportunity to participate appropriately. You absolutely were, which is why they gave you the chance. And then she got mad because in the original letter, they said, if you don't choose, the mediation will be unilaterally scheduled and we won't, even take you into consideration. She got mad. Why wasn't it unilaterally set? If you weren't going to listen to me anyway, then you should have chosen the date. It specifically states, quote, please respond to this correspondence within 20 days of receipt with your preferred date and attendance method. Otherwise, we will unilaterally schedule the conference and send you the details. I did. And I did with my request to help give me a better understanding. So why wasn't this unilaterally scheduled as stated? It was canceled. Would it have been better on my part to have just not corresponded at all so this mediation could have been unilaterally scheduled? I feel if I had not made my willing and eager attempt to abide by everyone's rules and played the part of the terrible low-life inmate former husband and what seems to be everyone else wants me to be, I would be preparing, reviewing, and working around this unilaterally scheduled mediation. I do not understand. No one has made any attempt to help me to. Honorable Dean, please understand this mediation is everything and can help ease the ongoing pain of whatever former husband's daily terror is he choosing to inflict. Makes me beg pitifully for pictures, which I still have not received. Has me call every week to ask for commissary funds so I can purchase necessities and sugar for my glucose concerns. Glucose? I thought you had cancer. So she's mad that they were going to choose a date without her. And then when they said, you know what, we're done with this in general, she's mad that they didn't choose a date without her. These are the consequences of your actions.
Well, if it isn't the consequences of my own actions, what's up?
When you zip someone in a suitcase and they die, you go to prison. When you are uncooperative and an abusive, berating ex-spouse and current abusive parent, these things happen. These are the consequences of your actions when you refuse to participate. And you're saying you didn't refuse when you literally said, quote, this makes it impossible for me to choose a date. No one has a crystal ball.
I do not know 4 months in advance my location or status, making it impossible to determine the best date to choose from which you have proposed. As said, I do not know what date is best for me considering my current situations and now health complications. By answering and explaining further the aforementioned concerns and questions will most definitely assist in my decision making. Your expedited response is greatly appreciated, as well as providing all requested documents and information. You are saying point blank period, I will not cooperate until you give me what I want. And he doesn't have to collaborate with you on the joint stipulation. He just has to present it, and then y'all go back and forth about it. But he has the right not to do it altogether and take you to court. That's why we are an adversarial court system, because you can do this. You could have done the same thing to him. You know you would have lost, and that's why you want to avoid this at all costs. But you should have kept that in mind. Same thing, you should have kept that in mind in the past when you said, I need a lawyer. I can't do this without a lawyer. You should have acted like it. But because you act the way you act, things happen to you the way they happen to you. Okay. 2. Regarding the respondent's accused, quote, chaos in her incarceration and the time of to present, the only, quote, chaos generated has been from the petitioner and his counsel's uncooperative, disruptive attitude, which has made this entire process more arduous and worse for her, their son, and the court. Both have committed perjury on multiple instances in writing and verbally to the court, ignored the judge and respondent, and continue to be a part of the problem instead of the solution which the respondent has ceaselessly attempted to generate, to be a part of her case completely. From her cooperation, attempted solutions and ongoing answers, resolutions, and provisions could have been made in avoidance of trial, all costs included, and continued disruption for all parties. Many items could have also been solved would the meeting of attorneys and unrepresented parties been scheduled as ordered. This is a further example of the petitioner and his counsel's added, quote, chaos and not the respondent's. Respondent has been transparent, properly corresponded when prompted, provided innumerable solutions, vigorously attempted to be included in this case by the petitioner and his counsel, and cooperated in every manner possible throughout the entire process. The petitioner has and still does not include the respondent in their filings, correspondence with the court, in this case as a whole. The respondent has contacted the petitioner asking why her exclusion continues, and his counsel via handwritten letters with no response, because they don't have to. What's wrong with you? Like, yes, he is supposed to let you know after he files it so that you are properly aware and you should have gotten it. I do question whether she was sent it or not, and she's just saying she didn't receive it. She says she didn't receive a bunch of stuff, and the court flat out told her it was mailed to this address. Well, I haven't gotten it, okay?
I know that you had brought up concerns regarding mailing, and I just wanted to go through the historics with regard to the mailing. Thereafter, there was an order setting hearing that was entered on July 29. That letter, or that order rather, was sent to you at P.O. Box 9109, Seminole, Florida 33775, which is the Orange County Corrections Department mail address for general inmate mail. That was remedied the next day.
See, I knew it. I knew it was something that was so inconsequential and not intentional at all. She made such a big stink about this at the last hearing and made sure to needle it in every time she could to say, you sent my stuff to the wrong address. I could not believe she made 2 separate motion things talking about changing this address. Formal address correction. Oh my gosh. I remember, I could not believe she wrote a whole motion about changing her address. Motion for defendant's immediate address correction. We just did this one. What? Formal address correction. She did 2. She did this motion twice. It was mailed to your address. I don't know what you want. You're in prison. Things happen. My job is to send it to the right address. If you don't receive it, I'm sorry about it. but he doesn't need your permission to file that motion. If you were uncooperative, he can file it on his own. He doesn't need your permission. He does need to let you know so you can. And she said that her son had to find the letter, and that's the only way that she was allowed to know months after the decision was made. That is not great. However, because this is the court system, she needed to file a motion objecting to that or asking that to be denied. And if she hasn't done that, then it's going to stand up. And is that what this is? Yeah, even right now, this isn't a motion trying to strike that. This is a motion trying to strike paying for attorney's fees, or like not even a motion, but this section. But if she had submitted a motion saying this was not served to me properly, so I want this to be stricken and that we have another chance to file for mediation, that doesn't mean that he still has to meet with you to find dates. It just means that he could resubmit that dispension, and then you are present at that hearing, and then you go back and forth, and the order dispensing mediation is still granted anyway. The judicial assistant Henrietta Coffey previously warned his counsel via email 2/22/23 in another of their attempted filings, stating it will be stopped and not accepted if they continue to not include the other party, which is the respondent. She also, on more than one occasion, has been unfairly ambushed by trial from no inclusion by the petitioner where she believed she was being transported for case management conferences. She would request from constant exclusion and having no status of her case to be properly prepared to defend herself and attempt to represent herself as pro se, which petitioner and his counsel advantageously tried to have control over. What does that mean? You have not been unfairly ambushed by trial. Why? Because you found this out in 2022. We are in 2025, meaning you've known about trial for years. Whether you took it seriously or not, whether you were working on it or not, whether you were writing motions, going through evidence, doing the things you needed to do to prepare or not, is your own business. And the fact that you were tied up with your criminal court case, which sent you to prison for life,
Which sentences you to life in the Department of Corrections.
is also your own problem. That has nothing to do with this case, nor do they have to factor that in when considering a, quote, unfair ambush by trial. That is when you are not notified about trial. It happens last minute. You are not given the opportunity to respond, to object, to go over things. Yes, if you are not served things properly, that is a factor. So yes, you do have that in there where you can say some motions, some things were not filed, quote unquote, properly, allegedly. However, aside from that, you were given access to your discovery, you knew about the trial for years, and you knew why it was postponed, and you've been given the opportunity to file motions. It may not be all the time you want, and it may not feel fair to you, but you have been given the opportunity, and you're in the situation you're in solely because of your own actions. Brian did nothing to cause this, truly. And if you didn't do what you did, Brian couldn't do what he's doing now. To date, petitioner and his counsel do not include the respondent, take advantage of her circumstances, and discredit her truth in her pending appeal that is in process to disprove her charge and bring forth her proposed release.
Don't laugh. You can't laugh.
In their intentional exclusion and perjury, she should not be responsible for any supposed attorney's fees incurred by their attempts to continuously sabotage her lawful attempts to be successful in this case. I just want to know who's been lying to her and told her that she has a right to be successful in this case. This is an adversarial system. He is supposed to discredit your quote-unquote truth, which is just a delusion that once you win an appeal on a life sentence for second-degree murder, you are released.
Hey, Tiva, listen, you're going to jail. There's no other way to put it. Yeah. Have a good night, though.
You're not going to jail. You're going to prison. That way.
So she wants the judge to see how irrational he's being by discrediting her truth and trying to prevent herself from having a successful outcome. That is his whole point. He hired a lawyer for that specific purpose, to beat you. They don't have to make sure. She also has this weird conception of equality with a special misunderstanding of how that works in civil court. There is never an obligation to make sure everyone is equal the entire time. It's equal access, equal opportunity, not equal resources, equal knowledge, and equal ability to strategize and to get things done. People who have more money can get more things done. That's just how it is. And another big part of her manipulation and confusing the issue is she always wants to frame it as her success is dependent on resources and access and not on the merits of the case themselves, which is why I really love that line in Judge Cranick's order.
Triple B, actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought to defendant's attention on May 10th, 2022.
Because we've been saying it, but it was just very bluntly worded of she is trying to distract so that the case will not be resolved on its own merits. And we see the same thing happening here.
The result of their growing unnecessary costs is due to the petitioner and his counsel being uncooperative, stating ongoing untruths, false accusations, causing innumerable violations of the respondent's due process and proper lawful inclusion. Their, quote, actions and failure to act ethically, lawfully, and truthfully necessitate their own attorney's fees. That's not how that works, right? It's kind of the spoils of the victor. You can ask the other side to pay for your attorney's fees for forcing you to go through this process. Whether I had to do my own things or not, whether I submitted 10 million motions or not, I had to do this because I had to go against you. And now that your ass lost, I'm asking you to have to pay for my attorney's fees. And that's what you do. That's what I was shocked about in the Depp v. Heard case, that when he resolved it to have her pay $1 million, he didn't even ask for lawyer's fees, which they paid easily over $10 million to try that case, both of those cases. So I, at a bare minimum, even if you weren't going to have her pay you the $1 million, I at least would have asked for attorney's fees. But no, just wanted to cut that thread and be done with it. And that's also the easiest way to tell who the real abuser is what's the end goal. Most victims want to be away from their abuser and to cut it and that be it. Johnny Depp was awarded $15 million, technically $10.3 million, but settled for $1 million just to be done with it forever. Meanwhile, his abuser asked for $100 million and was going to fight for every penny if she had won, can guarantee. Similarly, Brian wants her out of his life more than anything, and he submitted a motion that I haven't gone through. I will probably do a follow-up video and go through that to just show the contrast of a rational approach versus a psychotic approach that we're going through now. But in that document, he makes way more concessions than I ever would and tries to meet in the middle on some things just to be done with her, just so this can end and he can finally get his life back. But who is the one who, regardless of everything, knowing this isn't happening, is asking for $67,000 regardless? Yeah, I fear Lana was her filter and kept her in line, saying, hey, actually try to be respectful in the court system. And now that Lana's gone, so are Sarah's morals. Well, they were never there, but her ability to be respectful is gone as well. All attorney's fees were and are self-inflicted by the petitioner and his counsel. That's just so funny to me. Like, yes, all attorney's fees are self-inflicted with anything. That's why when you win, you get to say, hey, judge, make them pay this for me because I don't want to do it. And the judge is like, okay. Resolutions. 1. Respondent requests for the court to deny the petitioner's proposed award of any attorney's fees due to their intentional and strategic exclusion of the respondent in their relentless attempts to control this case, including the court by overruling and ignoring, committing perjury to show the respondent is accused, uncooperative, and defiant. It is the petitioner and his counsel who are so. 2. Respondent requests an award of attorney's fees due to financial hardship and loss caused by the petitioner's failure to pay alimony with active agreements, court orders, and without modifications for over five years. 3. The respondent requests sanctions to the petitioner's counsel for his unethical treatment to her as a disadvantaged party in this case, continued exclusion, confusion, defamation so she cannot properly defend herself, encouragement of the petitioner to remain uncooperative, and blatant defiance to the court in ignoring orders, undermining its sole authority. She's trying, she really is, but let's go to number 2. Respondent requests award of attorney's fees. She's done this in the past too. There's nothing to award. You have no billable hours. You have done nothing to prove that you deserve to be paid for anything. You have not even incurred any costs. All of this is free to you. You haven't paid to submit a motion. You haven't paid to do any of this. And you're just throwing out arbitrary attorney's fees. Are you want to say, pay me his hourly rate for what I worked on my case, even though I didn't document it? It's just dumb and sounds childish. Nana nana boo boo, that's on you. You did it to yourself, and actually, I should get paid attorney's fees. Where's my $15,000 for representing myself? Hatred for all those who did not include me to receive my $15,000 share I worked for when Judge Kranick forced me to be my own attorney, to represent myself as pro se.
Don't laugh. You can't laugh.
Bon appetit.
Wow, I cannot believe. I mean, we've reached just new levels, new depths of lunacy. I cannot believe she just said, where is my $15,000 for representing myself? Madam, I'm not sure you quite understand how a job works. Jobs perform services for individuals who need services performed. I'm not getting paid to unclog my own toilet. That's why I call a plumber. You need to be defended against your second-degree murder charge. That is a you issue. Our Constitution just affords you the right to have a court-appointed counsel when your broke ass can't afford it.
Insufficient funds. You ain't got no money.
But that is not at all to say that you are supposed to get paid for doing any legal work whatsoever, especially when it's on your own case. I mean, how dumb can you really be? You are not and never will be a lawyer, nor will you be paid like one. And accusing them of and committed perjury. You have been caught perjuring yourself so many times.
I lied to the police. Basically everyone, because I was extremely fearful of being arrested. I made the first attempt of me calling 911 by telling them what happened, and I thought they were going to help me, but instead I was arrested for calling 911.
So you made a decision to lie?
I did.
Did you stay with that lie?
I did.
The thing is, you want all of this, all that to be able to defend yourself. Defending means going back and forth, meaning in court, you get to say, this is the truth, this is my truth, this is my evidence. And they get to say, hi, this is the actual truth, this is the actual evidence. And then they just get to show your words. His words don't look bad. You've tried to make them look bad, and they look rational and reasonable based off of how you are berating him. Meanwhile, you are trying to form him into some malicious monster in a way that makes you look more monstrous because you're just insulting them the whole time. And then asking for them to be punished because you feel bad. And I passed something up here about her again saying that she is going to be released. They are trying to discredit her truth in her pending appeal that is in process to disprove her charge and bring forth her proposed release. She does not understand that is not what the appellate process is for at all. One, first and foremost, these are two different court systems. This is civil court versus criminal court. His counsel for family court does nothing and has nothing to do with your appeal process. Nor does Brian whatsoever have anything to do with your appeal, nor can he influence it. This is something completely separate from the family law case. So it's impossible for him to discredit your alleged truth in your pending appeal, especially since right now you don't have an appellate lawyer. And you know what? Why not? I don't know when I'm going to include it. I don't know when I was going to do my own video on it. So I'll just do a little detour here, put it in here, clip it out, make it its own video later. That's called multitasking, sure. But yeah, right now, Sarah Catherine Boone Paulsen
Eating my peach.
I don't want a cupcake. Please.
doesn't have an appellate lawyer. Because just like the 8 others, 9 others essentially, 8 others, they withdrew. Damn.
Yeah, double homicide.
Bitch.
No, I'm sorry.
She just has the worst luck with lawyers. And again, I'll be honest, this one is not her fault. Motion to withdraw and request for appointment of new appellate counsel. Comes now the undersigned court-appointed conflict counsel for the appellant and, pursuant to Florida Rule of Appellate Procedure, and Rule of the Florida Rules of General Practices and Judicial Administration, respectfully moves to withdraw as counsel and requests that new counsel be appointed. In support, counsel states 1. Appointment and procedural posture. The appellant, Sarah Boone, was convicted in the Circuit Criminal Court and subsequently filed a notice of appeal. The undersigned was appointed by the lower tribunal as conflict counsel after conviction to handle the appellant's appeal pursuant to Chapter 27, Florida statutes. A notice of appeal has been filed, and the undersigned has complied with the appellate rules by filing the necessary statement of judicial acts, directions to the clerk, and transcript designations. 2. Good cause for withdrawal. Rule 9 provides that trial counsel may not be relieved of duties except with approval of the lower tribunal on good cause shown. The undersigned is no longer practicing appellate work or accepting court-appointed appellate cases, which would make continued representation a hardship. Continuing to represent the appellant on appeal would materially impair counsel's ability to provide effective assistance and would delay or jeopardize the appellant's appellate rights. 3. Need for appointment of successor counsel. Because this is a publicly funded appeal, the appellate is entitled to the continued assistance of counsel. Rule 9 directs that in publicly funded appeals, the lower tribunal should appoint the public defender or the Office of Criminal Conflict and Civil Regional Counsel or private registry counsel to represent the defendant on appeal rules. The undersigned therefore requests that the court enter an order relieving current counsel of record and appointing appropriate successor counsel. 4. Client contact information. Pursuant to rule, counsel provides the appellant's last known contact information, Wherefore, the undersigned respectfully requests that the court A. allow counsel to withdraw, B. appoint the appropriate office, public defender, regional conflict counsel, or registry attorney to represent the appellant on appeal, and C. grant such other relief as is proper. Joshua E. Adams. But yeah, now her pending appeal is even more pending because she doesn't even have a lawyer to pen the appeal. But she is saying her pending appeal to disprove her charge. You can't disprove your charge because you effing filmed it. What is wrong with you? You can't disprove the film you took on the phone you told them to look at for the videos that you took of him abusing you, but only shows you murdering him. There's no appeal, no explanation in the world that can disprove what you did. The best case you ever had was to try to justify what you did, not to disprove it, not to say you're innocent and that you had nothing to do with it. You 100% did this in every reality that exists because you documented it, because you love to document stuff and bring forth her proposed release. The absolute best outcome she could possibly have is that they tell her, okay, fine, we're going to send you to life again. But honestly, she would love that because she would be in the limelight again. She gets to tell everyone what a terrible person George is, what a terrible person we are, what a terrible person the family is, what a terrible person the court system is, what a terrible person humanity is to her, and what an amazing person and gift to humanity she is. She's going to be so mad when that appeal fails, and I'm looking forward to it. Okay. Moving on. Oh, this is her witness list. Witnesses. A witness list giving names and addresses of all individuals who may be called by each party to provide testimony, including impeachment witnesses and expert witnesses. Number 1, Sarah K. Boone, respondent, former wife, mother of minor child, located Ocala, Florida. Brian C. Boone, petitioner, former husband, father of minor child, location Gainesville, Florida. 3, Philip Paulsen, brother of respondent, location Altamont Springs, Florida. I mean, you can also say uncle of minor child as well if you're just going to keep consistency, but whatever, it's fine. Wait, those are your those are your 3 witnesses? Your witnesses are you, Brian, and your brother? Is your brother an impeachment witness or an expert witness? Or are you the expert witness? Okay. Trial exhibits. A detailed schedule of all photographs, exhibits, and documentary evidence that a party proposes to use, including impeachment and expert witnesses. The schedule should include enough information to identify each specific document. General categories of documents are not permitted. Composite exhibits are permitted if they are specifically identified. Number 1, marriage settlement agreement signed by both parties 2018. 2, parenting plan signed by both parties 2018. 3, parenting and divorce certificate Brian Boone 2018. Parenting and divorce certificate Sarah Boone 2018. Final judgment of dissolution of marriage 2018. Supplemental petition for modification of final judgment summons 2022. Respondent's answer to supplemental petition for modification of final judgment notice of filing 2022. Petitioner's verified petition to relocate summons 2023. Respondent's correspondence to judge and motion for contempt 2023. Respondent's correspondence to judge regarding motion for contempt 2023. Respondent's OCCD commissary records 22520 to 2124. Petitioner's Certificate of Compliance with Additional Updated Mandatory Disclosure 2025, Petitioner's Family Law Financial Affidavit 2022, Petitioner's Family Law Financial Affidavit 2025, Petitioner's Account Statements 42624 and 32725. Oh, wow. That's a lot. Okay. Wait, do I want to read this? No, these are literally just respondents, correspondence, requests for initial disclosure, witness letters of criminal crime, current interest rates, alimony arrears, myfloridacfo.com. Okay. Personal property car estimates for multiple websites. No, I need specifics. Why not just list the websites right there? But okay. Certificate of destruction, personal property vehicle. Oh, you have oh, that is so funny. Oh, I love that. But again, it's not his responsibility to keep track of your personal property unless you have some agreement in writing or document it. You can try to get that jail phone call where you ask him / beg him to hold on to your stuff. But that jail phone call is going to have to state that he is knowingly agreeing to hold on to your stuff for the entirety of your incarceration. If it is just a vague, general, okay, I'll take it for as long as I can, or okay, I'll move it to our place for whenever. If it is not specific, that is not a binding agreement. DOC canteen items with current pricing fluctuate with vendors. Is she trying to say this is my costs and stuff? Whatever. GTL communication current pricing phone calls. JPay communication features and current pricing, video visits, pictures, messaging, stamps, video games. But the thing is, you want these prices of all these things that you've never paid for. And if anything, adding all of those prices being like, I need to pay for this, that I've been getting this, shows how much money he's truly been giving you consistently. Exhibits attempted by respondent to submit. Okay, so these are the actual trial exhibits for both of them. Okay, I see. So this is what's actually up on there. Okay, so maybe Brian is using those as well to show. So it could be reversed. Brian's bringing up these communication pricings to say, hey, this is what everything's currently costing me. Okay, exhibits attempted by respondent to submit. Number 1, OCCD and DOC recorded telephone calls denied. 2, OCCD and DOC tablet messages, no responses, denied. 3, copies of case documents from clerk of courts, $404, unpaid. 4, petitioner's complete financial documents records, denied. 5, motion for counsel to be appointed to respondent, denied. 6, motion for guardian ad litem, denied. 7, letters to formal counsel for irreplaceable case documents to be returned for trial. 4, no response. 8, requests to classifications department regarding visitation. 8, not processing to date. 9, letters to petitioner regarding visitation applications. 2, no response. 10, tablet messages, DOC to petitioner regarding visitation. 18, ongoing 8 months after court orders to submit. No response. 11, USB drive from clerk of courts for trial, waiting for 2 months to view from DOC, 7 requests to classifications department. 12, transcripts from case management hearing 9/19/22 stating petitioner to continue payments and constitutional rights violations from judge, unpaid. Okay. So the things she tried to submit recorded telephone calls, denied. Tablet messages, no responses, denied. And I'm like, are you trying to submit just to show he didn't respond? Are you trying to exclude your messages? Because if you try to submit the tablet messages, you have to submit all of them in order to prove there's no response. And in so doing, everyone gets to read how abusive you truly are and how your own words undercut and undermine everything you have said thus far. Even though, just like the videos on your phone, when you kept saying, so when you see my phone, you will see all the damage that he has caused me, the television that he has smashed. And then when we get to the videos, it's you berating him, assaulting him, belittling him, antagonizing him, needling him, threatening him, getting in his face.
So he always had something on his mind, which is why, again, I got the puzzles and the paint to try to get him off of it so we don't have a drink, or he doesn't have a drink. So when you all see my phone, you can see all of the damage he has done to me and the videos of him smashing my television because he's belligerently drunk. Where most of the time, I just don't want to be there. And I try to help him. I try to calm him down. Eventually, he just passes out.
You're despicable.
How am I despicable? I'm not even doing anything.
Leave me alone.
Nothing to me.
You do everything to me all the time. All the time. Heartache and pain is what you cause me. Heartache and pain.
How is that?
Keep going. And I dare you. I dare you. I dare you. You get on your fucking little bike and go to fucking work tomorrow. Don't look at me. Don't come close to me. Don't touch me. Do you understand?
What do you mean?
As of this moment, and until I can get you out, get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder. I will scream bloody murder. Get away from me. I'm gonna fucking hurt you.
No. Good night, Sarah. Love you.
I don't love you. I don't like you. I don't want to be with you. After you begged and pled and cried,
Yeah.
I'm gonna trust you.
I know. I'm not struggling myself.
Say it. Begged,
Yes.
pled, cried.
You begged.
I didn't. You did.
Well, whatever. Okay, yeah, I did.
Say it.
It's 6:13 and I asked him not to play music. Because I told him that I was gonna go to shit. Are you gonna be nice tonight?
Yes. I promise you. I used to
Go for a walk.
by myself.
Yes.
No.
Go for a walk. Go get your fuck card shit.
What are you talking about?
Your retard paper. Don't hit women.
Have I hit you? No. So where are you going with this?
You took my car keys.
I didn't take your car keys.
You did.
It's all my fault. She has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. But we are not the type of people that you guys are portraying us to be.
She especially.
Especially her. So please, if you can,
Dismiss
this case.
Closed.
Drop it. She is not the type of person.
Good person.
She's a great person.
Angel. Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
And you thought that would make you look innocent. Seemingly here, all of the messages you send Brian and your son and your brother and Lana are abusive in nature and to their core. So you're actually lucky that they denied taking those tablet messages, because then you really would have been embarrassed. In the recorded telephone calls, I guess it depends on what she was trying to submit. But if she was trying to submit the recording where he, I don't know, formalized accepting responsibility for her personal property, I mean, it still isn't enough to be binding, but I guess that's what she was trying to say. Or no, in all these messages, she said, this is a follow-up to our conversation that was recorded on telephone calls, and they get to hear how nasty and mean you were to me. Denied. Copies of case documents from clerk of courts, $414, that's a you issue. The court didn't deny taking it. You want the petitioner's financial documents and records? Yes, this is also a form of abuse, because she is trying to dilute the issue to, similarly with her criminal court case, she tried to dilute the issue to intentionality and to the 2 little fingers. So she was trying to make the issue not about the vicious and malicious killing and murder of George Torres, but about it not being intentional. It wasn't her plan, and he had 2 little fingers in a way to get out. So she ignores the core issues, which is that she is a violent abuser who assaulted him with a bat, physically, emotionally, and spiritually harmed this man to death. Ignore all that. Focus that it wasn't intentional and that it was self-defense that she threw in there at the last possible second. The fact that she completely flipped this switch on a dime 2 months before trial after 5 years, nearly 5 years, claiming you didn't do it, you're innocent, and then saying, okay, I did do it and I lied to everyone, but it was out of self-defense. I don't think I have ever seen that work, where someone makes a last-minute change to self-defense after claiming to be innocent, and then it actually working out for them. But she tried it, and she failed. Motion for a guardian ad litem, denied, because that's not important in this case. That's not what we're discussing right now. Yes, your parental rights are up for grabs, but the child is not the one that is actually involved in this. She wanted to use that guardian to harass Brian, to get all this dirt in order for her to benefit. And that is the exact opposite of what a guardian ad litem is for. It is not for parental benefit, solely for child benefit. This has to deal with your alimony, your divorce settlement, and this just contradicts everything she's saying. She always tries to blame Brian of, he keeps bringing our son in, he keeps doing this and doing that, how dare he, when all she does is bring the son in. She has mentioned the son's name more than anyone else. Well, not even his name, but just the son, and used his status as a minor child for her own manipulative benefit, never for his benefit. Anyway, respondent graciously requests the court's understanding and consideration in the crucially limited supply of her exhibits, seeing her good faith efforts to obtain many others but unlawfully withheld financially from non-payment of court-ordered alimony from the petitioner, unresponsive parties, and denial from the court due to her inexperience as an attorney in representing herself as pro se. She has ceaselessly remained proactive in her parental and representation attempts in achieving truth, justice, success in her present and undetermined circumstances to the best of her limited abilities.
So what even was that? What were you requesting? You didn't actually ask for anything in that whole whatever you call it. You said respondent graciously requests the court's understanding and consideration. Two abstract things that are not concrete or defined, and you want this understanding and consideration in your crucially limited supply of exhibits, meaning I haven't been able to get all of the evidence I want, so I request that you understand and put that into consideration when weighing my actual lack of evidence to validate my claims. Just know, because I was unlawfully withheld financial non-payment of court-ordered alimony from petitioner and the unresponsive parties, and denial of the court yourself, due to my inexperience as an attorney in representing herself pro se, there's just so much in there. One, you're not an attorney just because you're representing yourself pro se, whatever. You're also funneling the accountability into an answer that no one agrees on. You're saying that the only reason you're failing at all of this is because you're doing this pro se. No. You would also be failing to a similar degree with an attorney because all of your behaviors and facts stack against you, and your circumstances are well understood by everyone else but you. And if you had a lawyer, he would have actually done the mediation and you could have avoided trial. But no, you are who you are, you act the way you act, and now we're here. So yeah, that paragraph's not asking for anything other than to be nice to me. And if you're not, then you're not doing what I'm asking you to do. And then wraps it up with, she ceaselessly remained proactive in her parental and representation attempts in achieving truth, justice, success in her present and undetermined circumstances to the best of her limited abilities. Just say, I'm trying my best. Good grief. But even then, you're not trying your best. You're trying your absolute worst. You're trying to control things to the best of your abilities, but you forfeited all that control when you stole all that control and autonomy from George. And we're back. Yes. And she's not able to zoom out because she's not able to actually properly categorize her abusive actions and see them for what they are. So she says things thinking that they're going to be interpreted one way when they only reveal the more abusive pattern overall. She is telling you, I have not stopped for a single moment harassing and abusing my ex-spouse and my son in order to gain their resources and force them to love me. So please, keep them chained to me and give me all their money anyway. She doesn't get that that's how rational people view this situation. And there's that word success again. Truth, justice, and success. She hasn't quite put it together that her achieving success in any of this would not be because of any truth, and it would not be justice. Your circumstances have been determined. You are trying to undetermine them, but they have been determined. Also in here, she asked for letters from former counsel about them not giving her documents for her trial, Multiple issues. One, these are just allegations. Two, those are confidential correspondences. You will never, she's done this multiple times. You will never get letters or communications from your lawyers and have them publicly viewed or accessible. In rare cases, maybe, but in general, no. These are lawyer-client protected communications. So no, you cannot use your letters to abuse people later on, retroactively. Plus, your letters are literally hearsay. You don't need letters because you're just going to testify. Just state what was in the letters. You don't have to say, I have a letter stating what I'm about to tell you. The weight of your word comes from your testimony then and there, or any other statements you've given under oath. Which honestly is probably why she didn't mention him in her criminal court sentencing letter where she was telling everybody off. Because I can guarantee she wanted to light his ass up too, but this was still happening. And anything she said in that case can be brought over into this case because she said it under oath. And if it involved Brian and involved relevant material, then it probably could have been used. I also believe that's why they didn't recall him on defense, because Brian just testified and that was it. They didn't cross-examine him because they said they were going to save him for bringing him into their defense case, which is dumb. At least during cross-examination, you get to lead questions, but when you're bringing them in the defense case, it's just all open-ended. You're never going to get the answers you want, and then you're giving Mr. J the opportunity on cross-examination to just paint the story and lead him to where he needs to go, which is another reason why the defense in the Karen Reed case didn't call Michael Proctor and give the prosecution a chance to testify on his behalf. But I think they were worried that if they recalled Brian, the answers that they would have elicited could have harmed her in the future. I don't think she was actually playing 4D chess in that way. I just think that was like an undercurrent of, if we get him back on the stand, he can say things that are even more damaging. Page 7-1, miscellaneous. A, request for amendments to pleadings, none. B, if this is a modification, filing dates and description of the prior pleadings, relevant final judgment, supplement proceedings, etc. Is this important? No, it's not. No. Okay. C, any issue the party wants to address at trial that is not addressed above. Oh, good Lord. Here we go. 1. The respondent's vehicle and storage unit in the petitioner's possession during her incarceration of 2020 to present. The respondent is requesting the petitioner provide communication history under oath and current status of her property and vehicle he willingly and voluntarily took responsibility for immediately upon her incarceration. Explain why he lied repeatedly, refused to utilize any of her many no-cost solutions she provided him, did not surrender her vehicle and storage unit to her brother who lives locally and was coordinated to receive and secure, knowing the importance to both of them the contents from their family who is deceased and to be passed on to her son. Signed proposed document stating he willingly abandoned respondent's property he personally placed himself as liaison over during her incarceration and was voluntarily responsible for. What does that even mean? First off, she's saying signed proposed document. Did she make a proposed document? Him stating he willingly abandoned respondent's property and personally placed himself as liaison over during. So she's literally saying, court, I want you to force him to sign a paper full of lies where he is admitting that he took possession of my property of his own free will, abandoned it, and agrees to now my lies that I've placed in his mouth because I'm asking you to force him to sign a paper. What kind of sense does that make? Where's she getting these legal rules or any... whatever. He personally placed himself as liaison. So you want me to believe that he contacted you from jail. He called you from jail somehow and said, hi, can I take your stuff for you? Can I take it? I want your stuff. I want to hold on to it. Or did you ask him? So he didn't personally place himself in anywhere. You personally placed yourself in prison. And now you're trying to put the expectation of
for your entire incarceration, to make such a big, humongous claim like that, it needs to be documented and signed. Because why? You're trying to have him sign some document stating that he abandoned his responsibilities. If you want him to sign that he abandoned it, you need to show where he signed that he had the responsibility and was voluntarily responsible for. You know what? You're correct with that. He was voluntarily responsible for until he voluntarily stopped being responsible for them. That's not legally binding anything. That is, you put your trust in him. If you didn't want him to do that, you should have called your brother from the beginning and had him do it. The fact that you did not do those things is a you issue. He was not your sole option. He was the option you chose because you knew you could manipulate him into agreeing to it. And I honestly would love to hear that conversation because it reminds me of the September 4th body cam footage. But when she's complaining that, after she's getting the police over there to arrest George for no reason, she's complaining she doesn't have a key and she's calling Brian saying, "Can I have a key? I know I was literally just there and could have asked for my key. Literally just there. But I need you to come here and bring me the key. It's my last option. I have no way." And it was in this very desperate, pleading voice.
Hey, if he's in the house, he's not coming to the door, but you have my spare key. I can't get in. If you could, there's no other way of me getting in my house. Unfortunately, can you please bring me the spare key? Yes, please. The front door and back door. I have no way of getting in.
So I'm imagining that on top of that original request of, "I'm in jail, I have no one, my family's dead," exactly all the reasons that you're giving right now, in order to manipulate the judge into feeling sorry for you, you utilized on Brian to manipulate him into feeling sorry for you. But whatever. Return all property in his possession which belongs to the respondent and provide information of whereabouts if unable. I mean, he's unable to do it because you can't accept these. You can't just say, give them to another third party because they're acting as my liaison now, because now we're in the exact same situation where you did this to Brian. So you can't accept personal property and you can't demand someone hand over things you handed over voluntarily to some other third party voluntarily if nothing was written down and this was all oral agreements that weren't actually agreements. 2. The respondent's request to produce and interrogatories. This request was sent to the petitioner's counsel to further her evidence of ability to pay alimony by the petitioner to the respondent after finding information from the limited bank statements she received prior. In her itemized research and calculations, with petitioner stating he was, quote, unemployed with no means of income, knowing from previous verbal statements he made to her he was working contract and had been since her incarceration. The spending totals did not suffice the income. Petitioner filed an objection citing the timeline to submit their production was improper and the information respondent was requesting irrelevant. A second set of interrogatories was requested with no response. And now with this case in trial, the respondent is confused what the point of the objection still waiting for judgment is. She has already been restricted access to this vital evidence in the meantime of trial and her preparation for in full application of. See, this is just another case of she's focusing on the wrong things. Just like she had the hyperfixation on the discovery. If I get the discovery, I win my case. So you not giving me my discovery is why I have to be so relentless. Now it's, if I get the bank statements to prove that you are employed and have the money to pay me, I win. That is the only thing I have to prove. No. Because him saying he was unemployed and did not have the income to further make $1,000 payments monthly. So you going to jail/prison took care of all that. Now that is taken care of for you, and you want the full $1,000 on top of those literal necessities being taken care of. But this is her pattern. She reframes the issue and then gets mad at you for not reframing it with her. I didn't intentionally mean to kill him, so I'm not a murderer and I get to go home. It's not my fault I'm in prison and can't fulfill my parental responsibilities, so I still deserve the full $1,000 a month and require you to make sure I get as much communication with my son, forced communication, court-ordered forced communication with my son as possible. Because I put myself in here. Okay, moving on. D. Any outstanding motions, all motions should have been heard or abandoned during the pretrial conference. The hearing for any motions other than for attorney's fees during trial request permission from the court. None. E. Request for judicial notice. 1. The respondent respectfully responds to the petitioner's request for judicial notice in their underhanded pretrial memorandum regarding notice of the entire docket of her criminal case. She firmly asserts her criminal file is irrelevant to this family law matter. Other than the fact she has been incarcerated over a momentary time period,
life in the Department of Corrections,
and with a pending appeal with petitioner, does not mention with opportunities for her proposed release. Because there are no opportunities for your proposed release from your pending appeal. Oh my gosh.
She really just tried to frame it as, isn't it crazy that Brian, the petitioner, didn't even mention that I have a pending appeal with the possibility of proposed release? What does she even mean, proposed release? That means someone would have to offer a proposition as like a time frame or an offer. You have never been offered release ever. Even your plea deal says after 15 years. You were never going to go through a court proceeding and then get released. You would have served time and then potentially gotten out in a decade. So now it's Brian's fault because he didn't bring it up, and that's him being shady and bad faith because he knows that my pending appeal has an opportunity for release. I just want to know who's lying to her. Like, you need to find some friends because the ones you have are lying to your face.
That's so annoying. And you're telling this to a judge, and you're trying to factually assert this to a judge. And also, you're trying to reframe this of your criminal file is irrelevant to this family law matter. It is because of your family law matter. The fact that you are being criminally tried for the second-degree murder of George Torres is the reason for the substantial change in circumstance leading to all of this. If you did not do those things and that criminal trial was not happening, then nothing would have changed. You would have been out in the free world. You would have been a drunk, got away with murder, further continued to both neglect and overwhelm your child, while only and solely living off of the funds from Brian. All of these things would have remained intact if not for this criminal trial. It is the most relevant part of this entire case. The issues before the court in this family law case pertain to civil obligations and rights, not, quote, criminal conduct. The respondent's entitlement to alimony, child contact, and parental relationship and related relief arises from established legal principles in family law, which are not negated by incarceration.
Oh, you wish it wasn't negated. You really wish. But your criminal activity can directly influence civil court. You're trying to say criminal court and family law are different. It's wild because she's trying to tie the judge down to paperwork arguments of, well, it's not in the stipulation that incarceration means I should lose this. Well, this isn't a criminal court matter, it's a family court matter. But family court examines reality as a whole, not just what's on paper. So you trying to get this little boxing the court into a corner only reveals your character, which is what they're actually judging. They're judging your fitness as a parent, your ability to receive alimony, and what that looks like based off of the current circumstances. This entire docket, like she said, I firmly assert, but also respectfully at the same time. I respectfully, firmly assert her criminal file is irrelevant because it makes her look horrible, even though the entire docket is a public document that even a 5-year-old can access. Actually, with the iPad kids of today, a 5-year-old probably could access it. Anyone could pull it up. They are telling you, they are putting you on notice, not that you have any ability to stop this whatsoever. Your court docket, your conviction, your sentence, it's all up for grabs because these are facts, not opinions in the way that you want them to be. You want it to be, well, until the appeal is done, none of this is real because I have an appeal pending. So we have to still pretend that I'm innocent until adjudged otherwise. Nope, that's what we did in criminal court, but you have been adjudged otherwise.
We, the jury, find the defendant guilty of murder in the second degree.
You have been adjudged a murderer. We don't have to say allegedly anymore. We don't have to do any of those caveats. This is what legally was determined by a jury of your peers.
Poll our jury.
Juror in seat number 1, is this your true and correct verdict?
Yes, it is.
Juror in seat number 2, is this your true and correct verdict?
Yes, it is.
Juror in seat number 3, is this your true
Yes,
and
it
correct
is.
verdict? Oh. Juror in seat number 4, is this your true and correct verdict?
Yes.
Family court judges are required to take into account the facts of the situation, not your feelings. Just because you feel it isn't relevant doesn't mean it is not the sole reason we are here.
Furthermore, introducing criminal records into this proceeding serves no legitimate purpose other than to heavily prejudice the court, slander the respondent, and distract from the actual issues such as needs financially and parentally with lawful compliance and inclusion. How would this prejudice the court? Okay, she meant to say heavily prejudice and slander the respondent and distract the court from the actual issues such as needs financially and parentally with lawful compliance and inclusion. Okay. In the petitioner's continuous vexatious and strategic attempts to make their own rules, disadvantage the already disadvantaged respondent with the unethical encouragement and direction of his counsel to do so and how, the respondent respectfully requests the court take judicial notice of their entire docket of violations. What? Of their metaphorical entire docket of violations, contempt, advantageous exclusion of the court and respondent, intentional confusion while displaying an ongoing, flagrant invincibility to any consequences for their continuation of, in the entirety of this family law case and all matters included. So she's responding to their literal request for a publicly accessible case docket, which anyone has access to. And they're saying, hi, this public document that everyone has access to, we would like to enter this into evidence. And she's saying, how dare you bring the most damaging piece of evidence into this? Just because I murdered someone does not mean I don't get to see face-to-face sun time and receive my free money. Anyway, but she meets that literal request with her figurative entire docket of violations. You know, just all these nebulous accusations. Nothing's itemized, nothing's documented, nothing's proven. It's all word of mouth. It's all just insults. And that's her main weapon. And it's also her undoing. And she did the same thing she did in the text messages with her son when she combined, you are lying to both me and son. You told me and son this. And now she's doing the same thing with the court and respondent, the respondent and the court. It's not just me being taken advantage of. It's both of us. Aren't you enraged? How could he take advantage of us? It's so manipulative and disingenuous. And you're talking to a judge who does nothing but deal with cases of manipulative and disingenuous parents. The court is respectfully urged to focus on and take under serious consideration all the facts included in this case historically and relevant to the law, and disregard any attempts by the petitioner and his counsel to use unrelated criminal matters to sway its decisions unfairly or unlawfully.
So, unrelated alleged criminal actions in order to sway the judge unfairly and unlawfully. You mean like bringing up your damn personal property 9, 10, a million times when that is completely irrelevant to these proceedings? Your personal property has nothing to do with your alimony payments or time sharing or anything. This is just an offshoot thing you wanted to shoehorn in there because you're mad he's not responding to you. Because in all your messages, you keep harassing him and he will not answer. And you kept threatening him by going to the judge, where the judge was going to force him to have to answer these things.
Do you really want me in your life so much to make me contact you every day, every day, every day? I ask as many times as needed to finally get an answer. If not this way, which would be more simplistic and less time consuming, especially for you in Gainesville, than in court, where you can answer everything when the judge asks you or orders you to answer? Don't you think? The reason for a very needed court date is simply over you not cooperating. You understand that, right? Then with all my paperwork, messages, requests, concerns, questions, etc., I'm going to submit. Everyone will see it. It's simply you taking up everyone's time. You. So simple. Please be part of the solution this year, not the problem. Cooperate and just work together, Brian. So simple. Is it because I'm trying to send all of my documents to the judge about you that you are not allowing me? Quote, alimony is for housing, medical bills, food, important things. It's for anything I need now and futuristically.
And now that isn't happening, so you continue to bring it up. She literally just defines actions that she does and tries to say the other party is doing it, which then only highlights the fact that she's doing it, and then only highlights the fact that she understands she's doing it because she just told us she understands the concept to begin with.
2. The respondent also respectfully requests from the court to take notice of the petitioner's payments described in their supplemental petition for modification, stated as being, quote, voluntary deposited money into the former wife's inmate account so that she may purchase items from the inmate commissary. Page 2, C. This, quote, voluntary deposits made by the petitioner are not pursuant to any court order or alimony obligation. They were willingly made by him after her concerns were made known of her needs not being met by the facility and should not be deducted. Oh, fuck. Oh, okay. Are you kidding me? Are you serious right now? She's saying that these voluntary payments, so every time she begged him, the 200, 300 plus times she begged him to send her money, she is trying to now frame that as that was all willingly made by him because he understood my concern that I expressed to him and he wanted to help me voluntarily. And that did not count towards any of the alimony payments. It's as if he didn't give me any money whatsoever. This was all out of his own willing, force manipulated generosity. Wow. Well, she's going to lose just because of this. It didn't matter what she says at a trial. This is enough to lose right here. Wow. Okay. They were willingly made by him after her concerns were made known of her needs not being met by the facility and should not be deducted or applied in any way towards legitimate alimony payments the petitioner has yet to make to her since she has become incarcerated from 2020 to present. You are shameless to a disgusting degree. The way that you berated him, and every time in those messages, you literally manipulate, saying, you are withholding my legal alimony payments. How dare you not give me money? And then he gives you money, and you're saying, finally, thank you for finally putting in commissary funds.
After you made me aware that you just purchased plane tickets that cost $2,000 and will not be adding funds to my commissary account for the second week. I explained to you,
Send me money, send me money, send me money.
I am a part of your budget. I am a part of your budget and should automatically be included in your spending and am doing without needs because you did not. I explained to you I need stamps, pens, and paper, and cookies for my blood sugar. I need these and was told I would have to wait until you are paid Friday for anything to be added. Next week is the third week you have not added to my commissary account. I explained to you also I am in the negative in my commissary account, and by next week we'll be close to $50 in the negative from you not providing funds. After you finally added funds for the tablet after my messages and added enough for me to print and do what I needed to do, I am unable to complete my task, work. You will not allow either way, and I still have nothing, anything I need or want. Books, food, stamps, socks, etc. You keep making me ask for updates like it's coming, and you've told me so many times in the past years it is. Nothing. Why would you do that? I can do everything without you except supplying funds, which is your responsibility of alimony.
Send me money, send me money, send me money.
I do not have to speak to you or waste money on messages. I do not have to be ridiculed and abused or laughed at or called names. I've tried everything with you and provided innumerable, simplified solutions. You make everything difficult, more confusing, annoying. Going forward, when I have to call again from no responses, please do not call me names and lie. Please
Send me money, send me money, send me money.
provide funds for all the aforementioned you keep telling me you will and I need. No money is spent frivolously, except for all the messages you won't respond to, and I keep having to send from no updates or completion of anything, including for our son. It is such a struggle for me to ever remember why I married you and stayed married for 13 years, because you were broke and didn't have to pay for shit. Don't act like you...
With your broke ass.
I'm still dumbfounded you are enforcing the parenting plan while I'm incarcerated. Why? Beyond ridiculous. Why don't you
Send me money, send me money, send me money.
enforce or abide by the alimony section of the agreement? Quote, because I can't. When I ask you why you won't
Send me money, send me money, send me money.
put credits on the tablet so I can communicate with my son, send messages to you, or print any of my documents I need to mail, which I can't because I have no stamps from you, not
Send me money, send me money, send me money.
providing funds for me to purchase. Is it because I'm trying to send all of my documents to the judge about you that you are not allowing me? Quote, alimony is for housing, medical bills, food, important things. It's for anything I need now and futuristically. Housing, charged every day to live here. Medication, charged every month for including 2 surgeries I've had since here. Food, to maintain my blood sugar and another medical expense. I have nothing ongoing 4 weeks now from you withholding. We don't have to talk to each other. It's one time to just get me what I need and can have. You make it a million. Do you really want me in your life so much to make me contact you every day, every day, every day? I ask as many times as needed to finally get an answer. If not this way, which would be more simplistic and less time consuming, especially for you in Gainesville? Then in court, where you can answer everything when the judge asks you or orders you to answer. Don't you think? The reason for a very needed court date is simply over you not
Send me money, send me money, send me money.
cooperating. You understand that, right? Then with all my paperwork, messages, requests, concerns, questions, etc., I'm going to submit. Everyone will see it. It's simply you taking up everyone's time. You. So simple. Please be part of the solution this year, not the problem. Cooperate and just work together, Brian. So simple. Think about it. If you just ordered everything and allowed me to see my son, to Brian, sir, hot meals times 2. Why didn't you order, Brian? They just came without calling my name. And because you will not give me confirmation numbers to ask the rep, I again have nothing for New Year's nor for Christmas. Even after asking over and over and over and over, starting December 6th, today is the 27th, and you couldn't find 5 minutes to order? But keep telling me you would and were going to? Are your holidays complete and even merrier knowing you did nothing so I could have nothing again? Why are you continuously lying to me about everything? Lying about everything. It's just a hot meal that you permit me to have only about 2 times a year. Not even for Christmas. but kept telling me you would and were going to. How many more times did you want me to ask? Not even a hot meal for Christmas. Thank you, Brian. Oh, woe is me. Get the F over it. I will call this weekend, I'm sure, and must in order to try and figure everything out you keep telling me to do. I keep trying. Think of how often we would go over any of this, the millions of times you keep having me do, if you would just do. So simple. You keep telling me you will or are. Think about that too. Please make sure I talk to my son this evening. Also, I keep asking for your help on. It's been weeks. So simple. I call every night. I tell him too via tablet so he knows I'm trying and love him, which he can't read because you won't add credits so he can. I'll again tonight. See you soon.
So the whole time in your manipulated, twisted mind, you were holding in the back saying these are all willful deposits. None of that applies to alimony because it is not the full $1,000 at the first day of the month that accounted for our past alimony payments. Since he did not do that, he never paid me a dime. Wow, that just makes what you did to him and the things that you said while messaging him abusive and manipulative beyond measure. You used the alimony payments, you used your son, you used absolutely everything you could do. Your family's dead, everything you could use to twist guilt of how could you not give me money.
Send me money, send me money, send me money.
And then when he gives you money, you're now saying none of that counted towards alimony. Yeah, you deserve to lose everything. Here we are again. No one's going to feel bad for you. Okay. These added funds to the respondent had no agreed upon rules, stipulations, or attachments as such, including repayment, other than being simple voluntary contributions made to her by the petitioner and stated by his counsel in their proposed petition as, "You're not married. Why would he be giving you money unless it was court-ordered alimony payments? Why?" He expressed and you documented to use as evidence in this trial that has now been excluded, but in the text messages you wanted to use, you said he was not giving you payments. And then you acknowledged when he did give you money and that he should have given you more. And now you're saying it was all voluntary contributions. You are disgusting. Wow. Uh, yeah. Like I said, this is just her version of her criminal sentencing statement of I'm going to say absolutely everything I've wanted to say the way I've wanted to say it. This is my truth and it's the way that the American legal system should run. And if it isn't, it's corruption. I feel so sorry for your honorable Miss Jackson.
I'm sorry, Miss Jackson. Ooh, I am for real. Never meant to.
Because now she has to deal with this, and she's going to go either one of two ways. Either make a very detailed response, completely annihilating any claim left in here, or a very bare bones response, meeting the legal requirements and pointing out why all of this was irrelevant and not going into the specifics, and just be done with it. And either way, Sarah will be enraged and say it's not fair and say that she's being abused again and again, and it's nothing is her fault. Moving on. No court-ordered alimony payments have been made or obligations met to date to the respondent by the petitioner since her incarceration. 3. Respondent requests judicial notice for the overall undeniable misconduct of the petitioner and his counsel's unethical practices used throughout the entirety of this case and his representation, including advantageous mistreatment of the respondent in this case as a whole. Petitioner's counsel continuously deliberate misrepresentations and insubordinate actions have undermined the integrity of the court, its sole authority, and proper proceedings under Florida law, constitutional rights, and procedural fairness to all. She's literally just saying words. Sole authority, receding Florida law, constitutional rights, procedural fairness, not defining any of it or conceptualizing it and operationalizing it in the context of this case. It's just happening. Trust me, Judge, I was there. He said he wanted to be zipped in the suitcase. As a direct result of these violations, making this case unfair and unequal, the respondent respectfully requests the court to deny the petitioner's supplemental petition to modify, as it would be unjust to reward such dishonest behavior, an inappropriate example of the law. You know what an inappropriate example of the law is? Drumroll, please. Murdering someone. You literally want her to make a court decision on this. Just feels wrong. This is dishonest and inappropriate. No, this is just her trying to again reframe and misdirect the purpose of this. She's trying to say the trial itself is so unfair, which is why I should win, instead of actually letting, like Judge Kranek said in his order, letting the case be resolved on its merits alone. Her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its merits. And this is how she probably won all her arguments in her life, is by making the argument about the argument and not the actual contents of what started it and why it is happening. So because you're being unfair and mean to her right now, we shouldn't even be allowed to consider the actual facts and reasonings for how we ended up here. Just a mess. Sanctions for both the petitioner and his counsel should rightfully be applied in the favor of the respondent for such actions, in which she respectfully requests from the court in the conclusion of this case and family law matter.
Yet again, just asking for punishment without specificity. This is just another never-ending example of her morphing actual legal terms into emotional appeals and then expecting you to act on those emotional appeals as if they were being used in the valid legal context, which they rarely, if ever, are. Sanctions are a real thing. They are punishments or consequences based off of breaking the rules. There are types of sanctions. You have to specify what type of sanction. You have to specify the type of sanction. You have to hone it in on the actual conduct, meaning on this date, April 12th, 2023 or whatever, this is what happened. This was the violation that occurred. Here's the Florida law that says when this kind of behavior occurs, it should be sanctioned in thus way. So I am respectfully requesting that they be sanctioned in thus way due to all the things that I have just said. Also, see my attachments for my evidence to further support my request for sanctions, because you're supposed to bring things with a good faith basis, meaning if you put it in there, you genuinely want it to happen. For her, she's just throwing the words in there. I want you to take judicial notice. Again, another legal term. Judicial notice just means the court is going to accept this as though it were fact, and you use that for very on its surface facts. September 18th was a Monday in 2023. I don't know if it is, but it's something that's easily verifiable. Court records, public documents. You also say judicial notice, meaning we don't need to have a hearing. We don't need to argue why this should come in. We just accept that because this is a public legal document, this is fact. And normally the courts are like, bet. But she's saying, well, I want to put you on judicial notice for their overall undeniable misconduct by the petitioner and his counsel, for unethical practices used throughout the entirety of this case and his representation, including advantageous mistreatment of the respondent in this case as a whole. Not a single thing was defined whatsoever. What are these overall undeniable misconduct? You've been throwing out so many allegations, you need to pinpoint what you're actually asking sanctions for. Because these are all opinions. You trying to define what misconduct is will never work in the legal system, because you still think you're okay with all the actions you've done in your life. And unethical practices like what? No definition. Throughout the entirety of the legal case. Well, if this is throughout the entirety, why are you just bringing it up a month before trial? when you've known that he has wanted this petition to modify since 2022. An advantageous mistreatment of the respondent. Just another opinion. Judges don't like this either because it's like you're spitting on the law, right? You're saying these are actual legal issues that have definitions, protocols, procedures, and mean things in certain contexts. And you're saying, boop-a-doop-a-doo, I'm just going to use any word the way I want because I can. Doesn't this sound so smart? Now you have to side with me. It makes it look like this is a joke. It only highlights your true malicious intent, which is, I don't have any reason whatsoever. They made me feel bad. Now punish them. I'm not even going to tell you how I want you to punish them. I'm just going to respectfully request that you punish them to the fullest extent of the law. Petitioner's counsel's continuous deliberate misrepresentations and insubordinate actions have undermined the integrity of the court, its sole authority, and proper proceedings under Florida law, constitutional rights, and procedural fairness to all. There's just so much packed into there. Every time you think a clause or an idea is going to end, it just keeps going. So their continuous deliberate misrepresentations, she's not going to point it out what these misrepresentations are, but whatever they are, they're deliberate, Judge. Just trust me. And insubordinate actions. Define the insubordinate actions. You can say, on May 29th, 2025, you submitted an order saying we needed to have a meeting to talk stuff out, and that meeting never occurred. That is an insubordinate action that you could bring up, but you never do. You bring it up, but you never bring it up when it needs to be brought up. And that's important here, especially when you're asking for sanctions in the respondent's favor. There aren't really sanctions in your favor. A sanction being granted, I guess, would be in your favor, but it's not like I don't know. And as a direct result of these violations, the violations I still have not articulated in this section where I need to specifically articulate them, that's what's making this case unfair and unequal. And then respondent respectfully requests for the court to deny petitioner supplemental petition to modify, as it would be unjust to reward such dishonest behavior and inappropriate example of the law. It'd be 10 times more unjust to reward the dishonest behavior of this convicted killer, sometimes mother, just because she doesn't have resources and people are being mean to her. And also, a case feeling unfair to you or unequal to you is not a legal justification for striking the petitioner's supplemental petition to modify. If it were egregious enough to the point where it did actually disadvantage you and exploit you and all this and all that, maybe there's a better argument for it. You still have to articulate it, but maybe. But that doesn't exist here. However, this is the first thing she's actually asked for. I want you to consider my understanding and consideration for all of this and all of that. I want you to do this. I want you to do that. Judicial notice. Notice their entire docket of violations. None of these are actual requests. You are finally saying, deny the petitioner's supplemental petition to modify. That's the other thing. This judge is going to be so annoyed because she has to read through all of these and say, you asked me maybe 5 things out of these 33 pages. What are we doing here? Exactly, Linda. We want answers.
Good luck with that. F. Citations or copies of any case law to be argued at time of trial. Please see each section completed for the uniform order which case law included for application in and of. Girl, why don't you just copy and paste and put it right here? Why are you making people do more work and say, well, go, I did it up there earlier, so just go read that. Literally, whoever you have typing this up, have them copy and paste it just right here. But okay. G. Whether there will be a court order and or interpreters and any agreement between the parties concerning the sharing of the cost of same. The respondent requests to have a court reporter present to record, but due to her indigent status, has the inability to pay for. Okay, then don't ask for it. She can ask for a free one to be provided, but she can't just ask one and then have Brian pay for one. But also, it's recorded by audio or video recording, so you could ask for a transcript and access to those if needed. But I think she just needs like an objective witness or whatever in her mind to be like, see, someone else was in the courtroom to witness all the injustice and how I was railroaded. Okay. J. Good faith estimate. 1. A good faith estimate of the time needed for both parties to try this case before the court. The respondent simply and very respectfully requests from this honorable court to be heard, understood in her explanation and truths, and considered in all aspects, as does the petitioner, to maintain an equal level of the law and due process in her inexperienced and uneducated attempt to rightfully represent herself as pro se in this family law trial. In regards to a time frame for this to proceed, she is cooperative in any manner necessary for her full inclusion and opportunity in respect of the court's time and considerations. Okay, the first part was completely unnecessary. She just wants to know, how long is it going to take? Is this going to take half a day, a full day, 1 to 2 days? But whatever. I guess this was harmless. K. Financial affidavits. A new updated financial affidavit for each party shall be filed no later than 7 days before the pretrial conference. The respondent's handwritten financial affidavit was accepted by the court in the pretrial conference on May 29, 2025. B. No new financial affidavits will be accepted at or after the pretrial conference absent good cause. End of uniform order and respondent's pretrial statement. Jesus Christ, that was a lot. Yeah, that was a lot. Well, the mask is off, but I mean, I guess it's been off for a while. This all just screams, I'm the actual victim. I'm not the abuser. How much more do we have? Okay, maybe not a ton. Let's power through this. Supplemental petition for modification of final judgment. Inactive during respondent's incarceration of 2020 to present. Page 1, 3, substantial change in circumstances. A. Respondent became incarcerated February 2020. Petitioner seeking to modify shared parenting, terminated alimony, and child support. This document was filed over two years after respondent became incarcerated and has no judgment to date by the court. Final judgment and parenting plan open and active before and after this filing by the petitioner without any granted modifications. Per the marital settlement agreement, page 2C, which, quote, shall survive the final judgment and be binding upon the parties for all times, page 2D, a modification or waiver of any of the provisions of this agreement shall be effective only if made in writing, signed by both parties, and properly witnessed and notarized. No signature has been executed by the respondent on or in this inactive document she received via summons April 22, 2022, while at OCCD after not being included in prior filings to avoid being served and petitioner accruing unnecessary costs. This document has not been heard in court nor a judgment made, has been self-implemented by the petitioner and his counsel who willfully violated due process and standing court orders for over five years by refusing to acquire judicial modification and permission through formal proceedings. That's what this is. He did do this. The only arguments you actually have is that he didn't pay you from 2020 to 2022. The exact moment that he filed in 2022 was when he was okay to stop payment because they're going to court on this. And if he loses, he has to pay. If he doesn't, he does not. Moreover, the only reason this wasn't executed or resolved is because you didn't want it to be. Judge Dean from before decided to pause everything in your favor and wait until after your criminal trial in order for circumstances to be better understood before making the decision. 9. The court explained that the family case is on hold pending the outcome of the respondent's criminal case. 10. The court finds that permanent decisions regarding relocation and alimony should be postponed until the adjudication of the respondent's criminal case. so that circumstances are clearer. 11. The respondent was informed that she may opt for a final hearing on the petitioner's petition for alimony reduction elimination and her own contempt motion, but that the court would have to consider her current status of incarceration when making determinations. Because if you wanted him to rush and make the decision, as he told you you could, he would have to factor in that you are currently incarcerated, which is what you did not want factored in, and you still don't want it factored in today. That's why you want it to be assumed that the second-degree convicted murderer
Guilty of murder in the second degree as charged in the information.
sentenced to life.
Court sentences you to life in the Department of Corrections.
In the Department of Corrections has an upcoming opportunity for release. So now she's saying, because I stalled the proceedings because I wanted them to be in my best favor because they weren't at that moment, because they allowed me to stall, that means he's at fault because it still hasn't been heard, and it's your fault for not hearing it. She's going to be mad when they string this all together for her. If they do, because they really don't have to. Page 2, 4. Modification of shared parenting. Discussed and proposed in Section B. The children of respondent's pretrial statement according to the Uniform Order. Page 2, 5. Termination of alimony. Discussed and proposed in Section C. Alimony of respondent's pretrial statement according to the Uniform Order. Page 3, 6. Termination of child support. Both parties have mutually agreed verbally in court the respondent is not seeking to collect these payments from the petitioner. She is asking for the sum to be distributed to their minor son and for the respondent to be included in deciding how the funds should be used properly and accordingly.
So again, how is that you not asking for the money? This is for child support. In theory, that money was always supposed to be used for the child, given to you in order to use it for the child. That's the idea. You still wanted that, even though you're now saying we agreed verbally in court. Okay, you still asked for it once upon a time in a formal motion because you thought you were entitled to that too, so it had to be addressed. But now because she took it back, she keeps saying, I already told you I don't want them. I don't want them. Yeah, we still got to address them. Because the way you flip-flop on your word, we need it on the record why this is absolutely ridiculous and ludicrous.
Ludicrous going in on the verse because I never been defeated and I won't stop now.
That she would even propose that to begin with. And this is a lateral move. She's saying, I want the money allegedly to use for her son to buy gifts or whatever. Now she's saying, no. I want you to keep the money to be used for the child, but I want to decide how they're used properly and accordingly. So either it's a lateral move in the sense that you were always supposed to and intended to use that money to support the child solely, or you were going to use that money for yourself, and now you're saying, I don't need that at all. I just want to be the one who gets to choose how it's used. No. Because if you grant her this, every single penny that comes out of that account, she will say it was either misused, it wasn't done the way she needed it to, people didn't give her the total so that she could keep her records, that it's so unfair and unjust, and you know what? Since he can't do it, just give me the $6,000 and I'll do it myself. Which is ultimately still what she wants. If she was offered the $6,000, she would take it. She wouldn't say, no, I already said that I wanted that used, I want to keep that in the household where my child lives. No, she said, I want $67,000 taken away from my son, given to me, but also I want you to force Brian and the rest of the world to tell me that I'm using that for my son and that I should feel happy about manipulating $60K away from my child's upkeep. And I get it. She's upset that at the end of the day, she doesn't have anyone to take care of her. She has lived her whole life, or the life that has been documented and out there to this day, being taken care of by someone or ordering that they take care of her. And now that she has to do everything on her own, she refuses to accept that. It's still everyone else's fault because you're supposed to do this for me. My lawyers are supposed to take care of me. My judge is supposed to take care of me. My guards are supposed to take care of me. And she is floored when they don't bend over backwards to make sure that she feels happy, comfortable, and okay with every decision that happens around her. And if she saw herself as the murderer that she has been convicted as, then she could mitigate her expectations and say, oh, maybe I should be nicer because people think I'm an evil person already, and I'm not, so let me prove to them that I'm not. Her, she's saying, no, I'm a good person, and fuck you for saying otherwise.
Page 3. 7. Attorney's fees and costs. Discussed and proposed in Section G, attorney's fees and costs of respondent's pretrial statement according to the Uniform Order. In addition and conclusion, the respondent would like to reiterate to the court she has been proactive, eager for involvement, proposed numerous solutions, and cooperated in every manner with the petitioner, his counsel, and the court since the beginning of this case.
No one has a crystal ball,
making it impossible to determine the
best date to choose from,
telling me what I have to do.
Is the point of this mediation to try to
force me into signing
or agreeing to the only terms available presented by former husband?
What if I do not agree? I am not giving up
in any way.
Going to trial is a direct result of their egregious decisions to be non-compliant with multiple court orders, which could have been avoided from opportunities to collaborate, simplify, even conclude this matter prior to save time, money, effort for all parties, the court foremost. Because I have to appeal to you. You see, Judge, this is me kissing your ass.
And no, going to trial is not a direct result of their egregious decisions to be non-compliant. It's because you murdered George Torres. That's why you're going to trial, because he wanted to modify everything to begin with. Then you were uncooperative, and he was like, done. We're just going to cut it off. Why? Because I'm the one being nice to you right now. And she never really understood that. She thought everything was a right, and so she demanded everything from everyone, failing to realize the true charity people were performing and giving to her. And she spat in their face and said, you're supposed to do it anyway, and with a smile. And now that they said, you know what? Actually, I don't have to take the abuse from Drunky the Bear. Brokey the Donkey can sit her ass in jail for life.
To life in the Department of Corrections.
For all I care. So now we go to trial. This could have been simplified and even concluded the matter prior to saving time and money. How, when you are showing, you're not even showing that you're in a compromising mindset right now, when you are asking them that I didn't want this at all. I didn't want to go to court for this, which is why I'm at court asking for $67,000. In her mind, she's thinking, this is what I'm entitled to, $67,000, and here are all these reasons why. Because Brian's a meanie McMeaner pants, and his lawyer's a liar liar pants on fire. And that's the only valid argument I have. Please give me all that money. And she's thinking that because I gave you all these reasons, you're going to say, okay, obviously you don't need all that, so that's why, give her 40, give her 50,000. Maybe that's more reasonable. Maybe you could come together, and her compromise is the $300 a month at the first of the month, which would have been more reasonable up front. But now it's not reasonable because that's the max you can receive when you're on close management in prison. So it's not showing any good faith that you're coming to the table to mediate. You are still trying to max out everything that you can get and gain from him, and giving nothing in return. And this would have saved time, money, and effort for all parties, the court foremost. The court is there specifically for this reason. There's no saving time, per se. You're not going to get brownie points from them saying, hey, oh great, I'm so glad you saved time. Because when the judge reads all this, she's going to say, oh, there are so many issues here that absolutely needed to be addressed before 2025. But because she stalled, because she did all of this, again, for a 6-day trial and an hour-and-a-half verdict, with dinner included, so more like 45 minutes. And because of that, we've had to wait this long, and the issues keep compounding and compounding. She keeps getting more and more aggressive and angrier. And she's going to tell you, and she's going to look in your face being like, I'm so defenseless. I only try to cooperate. And then her exact wordings are, punish him. How dare he? He's so insulting. Can't you see I'm trying? That's how this reads. And if she had a real friend out there, they would have stopped her and said, hey, maybe not all of this.
The respondent should not be responsible for the petitioner's perjury, self-confusion, and lack of ability to maintain their manipulative attempts to strategically sabotage her in this family law case, and in their poor example of professionalism, ethical practices, lawful and respectful treatment of the respondent and the court. The respondent is profusely grateful for the court's invaluable time, patience, understanding in seeing her ceaselessly good faith efforts and determination in achieving rightful success in her son's life, lawful obligations, her appeal, and productively moving forward, regardless of time, location, or circumstances. So she's saying, look, Judge, see how hard I'm trying? That means you have to side with me. That's it. That's the argument. Don't literally anything. She wants you to do anything, but actually look at the facts of the case, her behaviors, and the circumstances she has put herself in. Are we done? Please tell me we're done. No. Oh, okay. Okay, one more thing. Okay, one more thing. We got this. Respondent's motion for contempt and to compel petitioner to submit visitation applications immediately. Comes now, pro se respondent Sarah K. Boone submits her motion for contempt and to compel petitioner to submit visitation applications immediately after raising her concerns to the judge as stated in the order after case management conference on May 29, 2025. The respondent has repeatedly been requesting from the petitioner to submit the visitation forms since her transfer to DOC in January 2025 without completion to date, and after innumerable reasons, excuses why he has not or cannot for ongoing eight months. This is the reason respondent made the emphatic decision to verbally motion the court in the conference to make aware of his ongoing untruths and difficulties in withholding her son from visiting, and for no valid reasons. Petitioner's counsel even volunteered to submit these applications on the client's behalf after being sanctioned for noncompliance of scheduling the required in-person meeting of the parties for the pretrial conference, also stated in the order filed May 30th, 2025, where to date, and after the court giving a two-week due date, no applications have been received per the DOC's classification department's most recent update to the respondent on July 12, 2025. Respondent has sent multiple tablet messages to the petitioner requesting status, even completed the applications for both and mailed with instructions they only need to sign and add work information.
And pause, because she thinks she's slick with this one. But it's twofold. One, she's sending it to them because she wants to show, oh, they're being so uncooperative. Look what I'm doing. I'm spending money to send mail to the man that I'm begging money from, who I'm also in contact with regularly because I forced that contact. But I'm spending some money to send even more things to him. But more importantly, I filled it out for him. All he has to put down is his employer information. She was trying to trick and bait him into admitting, oh, you are working at blank. But if you're an independent contractor or whatever kind of job you do, you can get away and around that. And actually, I looked at the form. All you have to actually admit is whether or not you worked at Florida Department of Corrections before. It says place of employment. Not actually, are you employed? What are the job titles, specifics phone number. What is this employer information? Literally, it is place of employment. Not everyone has a place of employment, so you could have put self, you could put NA, you could put anything. And the important thing is, did you work at Florida Department of Corrections? Because that's what they need to know. And they need to know that for security purposes, because normally when you worked at a prison and you don't work at a prison anymore, you normally don't go back to the prison. So if you do, they kind of want to know why. Why? Because you have all this information, you know the layouts of stuff. You could be, I guess, meeting with some prisoner that you were overseeing and doing, I don't know, smuggling stuff, bad things. So that's what that question is for. They don't actually care about your job, nor are they asking for your history, pay stubs, nothing to actually confirm it. So this was purely a fishing expedition, in my opinion, and trying to get him to admit on paper that he has a job, which still doesn't matter.
In her letter, she also explained again to him the importance of her desperately trying to see her son. And during one of his 100 days of summer before school starting, and after over five years of waiting prior in a simple video visit. Petitioner has not responded to any of her messages or letter, and upon answering a call from her, no responses, swears and tells her, quote, he'll check on it, then disconnects. This is the same reason he gave the court, still with no application submitted by either. These false statements made by the petitioner under oath and his counsel, in addition to their deliberate, continued, quote, chaos and noncompliance, is contempt. She is so mad they used the word chaos. She can't let it go. She had it in her other motion and she brought it into this one.
Also, what are the false statements? She's saying these false statements, what the quote, he'll check on it. That doesn't mean it was false. He could have checked on it and just didn't do it. They're deliberate chaos and non-compliance. Who is the one who has actually caused nothing but chaos in her whole life, in adult life, just ever? Chaos has surrounded her. That is the one constant and consistent everyone can agree on, is that she is a chaotic presence and brings chaos wherever she goes. And non-compliance. Won't agree to do anything that is not a specific idea that came from her mind. If anyone else proposes it and it's not 100% what she was already thinking, nope, not going to do it. I'm going to reframe. I'm going to force you to agree to what I have to say. And speaking of false statements that happened on May 29th, 2025, I saw on one of Tanika's videos, so we're going to take a little quick detour about her behavior logs, where she was charged or whatever, found guilty by the corrections department of lying to the officers on the date of this pretrial conference. The things she's brought up so many times. They lied. The court ordered you to set up this visitation and to do this and to set up this meeting, and you didn't do it. You didn't do it. You lied, you lied, you lied. Well, it turns out she lied to the guards. She wasn't allowed to bring in the tablet, you know, all these tablet messages, 1 out of the 100 of messages that I've sent him. She brought that into her meeting, which she's not allowed to do. And then when confronted, she said some other officer told her that she was allowed to do it. And then that other officer came forward and said, skirt F what you heard. I didn't tell her she could do anything. And she lied. And while that means nothing to her, lying and saying someone else gave you permission for something is a big deal, because that means they are breaking the rules for you for no reason. So she was found guilty, and she tried to write away this apology of, oh, there was just this misunderstanding. Like, I would never do that. Inmate Boone Sarah is being charged with 910 lying to staff member or others in official capacity or falsifying records. On May 29th, 2025, at approximately 10:29 hours, while assigned as classification officer at Lowell Correctional Institution Annex, while present in classification, I was approached by correctional sentence technician A. Sims, who informed me that inmate Boone, Sarah was attempting to bring her tablet with her into her telephonic legal hearing, and had informed Miss Sims that I had given her permission to do so. At no time did I give the inmate permission to bring her tablet to classification. Inmate Boone, Sarah remains in general population pending the disposition of this report. Oh wait, she was moved to Gen Pop? I didn't even know that. Go for her. The imposition of additional suspension of privileges and penalties was made to reinforce positive principles that could impact the inmate's overt behavior and thinking. In this particular case, the inmate stated she was given permission by classification officer Bowen Walker to bring her tablet to a legal call when she, in fact, did not have permission. Inmate was sentenced to 30 days canteen suspension from 6/5/25 to 7/4/25. Okay, so at least she got off it on 4th of July. Or maybe it was through that day. Appropriate offices notified by DR log being sent out to administrative staff and the priority sergeant and officer. So this isn't just telling a little fib, or else they would have probably just gave her a write-up and not an additional suspension of privileges. But no, they're saying this is a big deal because you were caught in a lie and then you lied again about lying. And if you keep lying, you ruin that reputation. Everyone's going to think you're a liar. So the next time you get into an incident like this, they're going to automatically assume you're guilty because it's just the behavior that you've exhibited. Now let's read her response to that and her defense of herself. It was my complete misunderstanding I could bring my tablet to my legal call, which had most of my documents I needed for after speaking to Miss Santiago about everything regarding my family law case. Miss Foss and trying to speak to the warden and trying to receive physical documents to not use my tablet. In all the emails, phone calls, and messages in Rex, I misunderstood I could use after meeting with Miss Santiago and discussing my options to be successful in my calls and case. We talked about many things where she was extremely helpful, and I did not understand about this. I would never disobey any rules of DOC or take advantage of the classifications department with ongoing, very needed help. I would never. Please allow me to speak at, I'm guessing, her hearing, because of course she's going to try to appeal this. I didn't lie, I just didn't know I was lying. But even this reads completely disingenuous. Linda can smell BS too when she sees it. You're over here saying it was my complete misunderstanding that I could bring my tablet in. And I'm talking to Miss Santiago. Didn't the other thing bring up a different officer? I don't think Miss Santiago was mentioned once. It was this other person. In this particular case, the inmate stated she was given permission by classification officer Bowen Walker. But of course, this is just a new redirect. Are you trying to blame someone else now? Being like, I know I told you this person told me, but actually it was when I was talking with this other person. And don't worry, we talked about many, many things. That's why I was confused. I thought I was able to do it. In your misunderstandings, it also, the way it's phrased, sounds like there was a conflict back and forth because she was caught taking the tablet in. She was probably told, you can't take it in, give it over. And she's like, well, I heard from this person that I can, Now we go back and forth. Oh, well, that was just my misunderstanding. How is it a misunderstanding? Did you say, could I take the tablet with me? Have you ever been able to take the tablet into other legal meetings? No. Why is this one special? And then she's also deflecting blame. Well, when I spoke to this officer and Miss Foss, Ross, whoever, and tried to speak to the warden and trying to receive physical documents to not use my tablet. See, I was trying to not do this. I was trying to not break the rules I told you I didn't know about because I needed physical stuff. Translations, y'all didn't give me the physical copy, so I was going to do what I was going to do anyway, and I brought my tablet to reference documents you probably didn't even mention in the hearing. And then just I would never disobey any rules of DOC or take advantage of the classifications department. Who do you think I am? Some kind of murderer or something? I would never do that. I would never. What does that sound like? That sounds like the same hollow BS she said at sentencing. I hope everyone can forgive me. Torres family, forgive me. Everyone, forgive me. Judge Cranick, forgive me. I didn't mean for this to happen. I would never.
Almost everything reminds me of him. Seeing my stab wound every day especially. It truly reminds me that all I really did live through. George haunts me. He is everywhere. I believe because I do still love him, think of him, and miss his laugh the most. In my heart, I know he is with me and understands that this tragedy was not intentional. I hope everyone can, his family foremost. I didn't mean for this to happen. Please wholeheartedly know that, and always, I would never. Forgive me, George. Forgive me, Torres family. Forgive me, Judge Cranick. To the entire planet, please forgive me. I graciously and humbly ask for consideration, for forgiveness to be extended instead of judgment, for reconciliation and restoration for all of us to move forward. My apology is profuse and ceaseless. Allow me, please, to brush off the muck, wipe the blood off of my face, and fix the cuts in my skin. I ask for understanding in what really happened and for how long. For second chances, repentance, and redemption to advocate for all domestic violence survivors.
And that's where I always have to cut her off because then she tries to claim to be one. And it's just so tone deaf and disgusting every time. Everyone forgive me. Allow me to wash the muck off and the blood off of my hand. George's blood? You want us to just let you wash George's blood off your hands and just act like it's nothing? That's literally what you said. No one ever had to say, let me wash the muck off and wipe the blood and the scrapes off of me, which just gives a horrifying image of you over him, beating him with a bat, pulling him out of a suitcase while he's bloodied and dead. So yeah, you have all the time in the world to wash that blood off your hands behind bars for life.
Miss Boone, court sentences you to life in the Department of Corrections with credit time served.
Because it's a fake BS apology, because in the same exact breath, literal breath, I would never do this. I'm asking for forgiveness and understanding about what really happened and for how long. Well, we're still trying to find out for how long. We don't know how long he was in the suitcase before he died. We don't know how long you had him in the suitcase because you're an oblivious drunk and a liar who won't actually admit to the truth. Sorry, every time I hear that statement, it boils my blood how even to that day, to this day, she considers herself a martyr for all domestic abuse survivors. You are a lesson for all domestic abuse survivors about what can happen if you don't get away. So they will never put their victims' safety, well-being, or anything first, which allows her to say the things she said in that video and then look at us and say, I don't see why you can't just get over it.
To the entire planet, please forgive me. I graciously and humbly ask for consideration, for forgiveness to be extended instead of judgment, for reconciliation and restoration for all of us to move forward.
Please forgive me, I guess, if you're making me ask you. That's how that reads. Just, I would never.
I would never.
As she doesn't even look up from her paper, so dead behind the eyes and just hollow words. But yeah, that made me chuckle a little bit because you're over here saying they lied on this date, hold them in contempt, they should be punished, sanctioned, buried under the ground, put them under the jail, as she likes to say.
up, you can go take that paper down to headquarters.
It's not hearing anything else because she's taking him down.
I
Put
mean,
him under the jail.
He's going.
Under the jail.
Okay. We're all set then.
Meanwhile, she lies on the regular and then takes it to the full extent. She couldn't just say, I accept that I was wrong. Because if she said, yes, I did lie, but that was just because I needed my papers for this very important conference. I tried to get them physically and I didn't, so I took it. And then when I was informed, I lied because I thought I desperately needed them. You still would have gotten punished for that, but people notice when you take accountability for things, and people respect when you take accountability for things. You've never taken accountability or responsibility for anything, not a single fault. Have documented records of you accepting. Every single record we have is you ducking, dodging. I'm not guilty. He did it. I'm not guilty. This other officer did it. I'm not guilty. Brian did it. I'm not guilty. The judge did it. I'm not guilty. My son is. But moving on.
Okay. Wherefore, pro se respondent Sarah K. Boone respectfully requests from the court to 1. Compel petitioner and or his counsel to submit the visitation forms immediately for her son and himself, remembering the process takes already a minimum of 30 days to process. 2. Sanction both for perjury, ignoring and disrespecting the court and respondent, causing emotional distress to the minor child in his continued attempts to see his mother, and violating the respondent's parental rights in avidly seeking and growing her parental relationship with her son. 3. Order such relief or disciplinary action as this court deems just and proper. Respectfully submitted on this 20th day of July 2025, Sarah K. Boone, pro se respondent. She always has to manipulate and add another dig. Number 3 is very standard of order such relief as the court deems just and proper, just to open that door of, and if there's anything else you want to give me, go ahead. Because if you don't ask for it, the court can't give it to you. But that opens the door. But for her, she's saying other such relief or disciplinary action as the court deems just and proper. If the court deemed it just and proper, that would just be a sanction, whatever she determines and how she determines to do it. But you just need to enforce it more. Punish him, punish him, punish him. See, look, for everything he's done to me, I want you to punish him. That's all. That's what this reads like. That's all this reads. And I will say, there is a valid argument here. If Brian was court ordered to submit these applications and he didn't do it, while me, my petty self personally, I love it, by court standards, that is contempt. And you can ask for this, but it's just the added, just unprofessional tone that just makes it all feel disingenuous and makes you seem abusive when you do have an actual valid claim. You saying submit visitation applications immediately, that immediately is so unnecessary. Cut that and you have a valid legal title. But no, you always have to try to one up and undercut and just get that last little needle in. And that is always what ends up being your undoing. Anyway, this was too damn long.
And that is going to be it for our pre-trial statement, exploration, catastrophe, whatever you'd like to call this. I call it too much because damn. Yeah, I mean, she's back in full form. I don't know why I keep thinking that every new obstacle and every new punishment she encounters might humble her, might make a more rational person. It doesn't. It just cranks her up and makes her even more bitter and angry at the world and think that she has a chip on her shoulder and that she is justified in talking anyway to anyone. And what we see from all the videos we've seen in the past and the text messages in the past, that's all she's done. She has always, I say this all the time, she finds the right ones to come at crazy. Because she hasn't met the truly right ones that would have sat her ass down years prior to squash all of this behavior now. But this is what happens. It's all catching up to you. So as of right now, it's closest to mid-August. August 25th is when trial is supposed to happen, and Brian and his son will finally gain some relief. And I know Brian did submit his stuff. I haven't read that. I'll do that in another video because this was way too much as it is. So yeah, to summarize the 33 pages, Brian needs to pay me money. He secretly has a job, which is why he should get sanctioned, and nothing should happen to me. You need to ignore my criminal conduct because this is civil court, family law. But this is the same thing you tried in criminal court. You try to get us to ignore your actions there too. And until you finally come to the realization of people treat me this way because of the way I treat them, then maybe you'll start to improve that behavior and your circumstances around you will also start to improve. I hope Brian is able to do any and everything in his power to protect his child from all danger and harm, yes, even including his mother. So, if you like this video, remember to like, comment, subscribe, dislike if you're feeling it. Until next time.